Ladies and gentlemen, lend me your ears and your eyes. Diva Divine Light, live from Brooklyn, New York.
No delaying for what you saying, yo. Silly with my 9 milli with the dilly, yo. When I be on my yes, I do my duty, yo. While up in the club, I be while in the studio. You don't wanna violate, nigga, really and truly, yo. My main thug nigga named Julio, he moody, yo. Like a nigga that'll slap me with the tulio. Bitch, nigga scared to death, act fruity, yo. Fuck that, nigga, shorty, she a little cutie, yo. The way you shake it, make me wanna get all in the booty, yo. With no delaying for what you saying, yo.
Diva Divine Light.
Really my heart to me. That's what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you really my heart to me. That's what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you.
You're watching Diva, the Divine Light. A fun-loving, caring, passionate person who talks about sex, celebrity, and real-life issues, and even abuse. So hit that like button and make sure you share the show.
Really my heart to me. That's what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you really my heart to me. That's what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you really my heart to me. That's what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you really my heart to me. That's what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you.
Here comes the pitch, and it comes in wide. On the combo.
Hello, hello, hello. Welcome back, everybody. Welcome back. Welcome back. So I hope everybody's having a great afternoon. Good afternoon, everyone. Those that are working, I know you guys will be listening, driving, listening. Please be safe. Don't get in trouble by your bosses. So we have Miss Ghislaine Maxwell's sentencing memo, guys. And I figured I'd read it so that we can kind of get an example of what was put into R. Kelly's sentencing memo that was sealed. Now, remember, they sealed it. We weren't able to see what was inside of it, right? Well, with Miss Maxwell, they didn't seal it. It is visible for the public. But what they did do was they redacted some areas, which I think is what they should have done with the R. Kelly situation. Just redacted some areas so we could see. But it is what it is, right? So before we get into it and get into all of that, let me greet everyone in the chat. My Nanya, what's up, baby? How you doing, mama love? I am Queen. What's up, baby? Vanetta, what's up, my love? Who else is in the building? Honey Bunny, what's up, my honey bunny? Indigo, what's up, baby? Cool Gamer, hey, what's up, Cool Gamer? How are you, puppy? Shay, what's up, Shay? Hey, Eva, SK. I see you got the situation taken care of yesterday. All right. Miss you too, mama. Hey, just the tea, please. What's up, lady? My bro, his lordship. What's up, puppy? Oh, you on vacation? Please enjoy. Stay away from the drama. That's right, puppy. Enjoy your vacation. Hey, rocking with the truth. What's up, sissy? What's up? What's up? What's up, everybody in the building? Let's see who else. Anybody else? Hey, Sonia. What's up, Mama Love? Hello. Just V, my freaka leak. Happy belated birthday, Mama Love. You know I love you. Tears. Babe. I love you, Tears. What's up, Mama? Hey, Tonbella. What's up, baby? Hey, Les Smith. What's up, Mama? All right. So while everybody's getting in and getting comfortable and saying hello to everybody, I'm going to show you guys a little bit of a clip from what's going on with Miss Maxwell. Okay, and this is from Law and Crime. So I want us to just listen to a little bit of it, and then we'll get into the sentencing memo. Okay? So let me prepare to share my screen with you guys. I got to go on mute. Okay, so under the Copyright Act, the fair use of copyrighted material without permission is allowed when used for the following purposes: for criticism, commentary, news reporting, and teaching. And I do not own the rights to this video. This video belongs to Law and Crime Sidebar. And thank you so much for your commentary and your work. I appreciate it that you are letting me use your commentary for teaching. Thank you.
Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. So Ghislaine Maxwell is awaiting sentencing after a jury convicted her of sex trafficking and conspiracy for her role in the grooming and enticement of minors to be abused by the late financier Jeffrey Epstein. Now, Maxwell is claiming that she herself was a victim while she was locked up in solitary confinement at the Brooklyn Metropolitan Detention Center in New York. Her lawyers are arguing that this entitles her to a shorter prison sentence. So the question is, what exactly is she alleging, and what does this mean? Well, joining me right now is Law and Crime Managing Editor Adam Klasfeld to break it down. Hey, Adam.
Hey, how's it going?
Good. I'm glad to have you on. Now, I'm really glad to have you on because you've covered this case from the very, very beginning. So what is Maxwell alleging right now?
So what she is alleging is very much what we've been hearing even before the trial began, that she has been under really harsh detention in pretrial lockup. And these were claims that were heard when she filed multiple motions for pretrial release that failed before the judge. And she is placing a very hard bet right now on her sentencing being determined by the conditions of her confinement. Some of these claims were rejected before, like, for example, her access to pretrial communications, that this was a case that spanned decades. She needed to basically examine decades worth of evidence, and before trial began said that the conditions of her confinement that were interfering with her ability to prepare for trial. Now, those arguments were rejected in terms of her arguments for pretrial release. Now she's claiming that some of, for example, that she was closely watched very often. We have to remember that before the Ghislaine Maxwell case even began, there was, of course, the Jeffrey Epstein case. And Jeffrey Epstein died in prison, and that essentially cause the BOP that she argued to be overprotective, keep a close eye on her 24 hours a day, that essentially interfered with her sleep. Before trial, there was an emergence of a photograph with the black eye that was never quite explained. So these aren't new arguments, but she is doubling down on it. There's a report recently that she filed 100 complaints over her jail conditions. And what we're seeing in her sentencing memos is her attorneys focusing on her confinement, playing down anything related to her relationship to Jeffrey Epstein, and not focusing so much even on what happened at trial, in order to get some leniency for their client.
Shocking that she's trying to do that. Shocking. Yeah, we're not really surprised that she's trying to ask for a lenient sentence. I guess the question is, I also saw this report that she said she was, not only tied down to a chair or handcuffed, and you mentioned monitoring, but that her life was in danger, that someone tried to attack her. Did I read that right?
You did read that right. Now, there was in her sentencing memo, one of the key things to emerge from that was an allegation that an inmate essentially said that if that inmate killed her, that she would be paid enough money to make it worth an additional 20-year sentence, so that she has faced threats to her life behind bars. Now, again, this might shed light on some of the things that we heard earlier about the close watch that the BOP was keeping on her, that they didn't want a repeat, essentially, of what happened to Jeffrey Epstein. And that's what essentially Ghislaine Maxwell's lawyers have been saying, that essentially, because they have argued she is a stand-in for Epstein, and that she has faced such harsh conditions and threats to her life, that they're trying to get some leniency out of that.
What are they looking for? Let's start. What is the prosecution looking for, and what is her defense attorneys looking for?
So the prosecution sentencing memo hasn't emerged yet. What we do know from the defense sentencing memo is that probation has recommended a 20-year sentence. The defense wants less than that. And we also know from the defense sentencing memo that essentially the federal guideline sentence are even higher than what probation recommended, that probation recommended 20 years, and that the guideline sentence is north of that. So we're still waiting to hear from the government sentencing memo. We'll find out what they're recommending, but we do know probation wants 2 decades, and that she recently celebrated her 60th birthday during the trial itself. So she was born on Christmas Day. So after Christmas Day passed, she turned 60. So a 20-year sentence is some serious time.
It really is. And when do we expect her to be sentenced? Is it next week? Do we think it's going to be delayed at all, or is it going to happen on time?
So it's going to be toward the end of the month. And just to get you the exact date, her sentencing has been scheduled for June 28th.
All right. And let me ask you, if you had to guess, based on everything you've seen in this case, again, you are the expert when it comes to Ghislaine Maxwell. If you said I was the expert on Johnny Depp and Amber Heard, you know this case backwards and forwards. What do you predict her sentence would be?
So without saying a number that can be thrown back if I get that number wrong, I will say that Judge Nathan is a tough judge. I do think that Maxwell has placed a really heavy bet on an argument that has failed in her courtroom many times before. I wouldn't be surprised if at least probation's proposed sentence were followed.
All right. Well, I'm not going to hold you to it. We'll see what ends up happening when she ultimately is sentenced. Law and Crime Managing Editor Adam Klasfeld, great to have you on. Thanks so much.
Thank you for having me.
Okay, Mr. Fowler, this complaint charges that in the town of Nantucket on July 8th, 2016,
Okay, guys, so that is just a little gist of what's going on before Maxwell's sentencing. Now, her sentencing day is on June 28th, the day before R. Kelly. So she's getting sentenced on the 28th. R. Kelly will be sentenced on the 29th of June. So, Miss Maxwell is complaining that she wasn't treated fairly while she was detained in the MDC. You know, she wants to live the lavish life. You know, she saw too many gangster movies where the prisoners are in a federal prison and they're cooking their own meals in a kitchen in their cell, and you know they got goons in there with them and they're being protected and they're eating spaghetti and meatballs and garlic bread and artichokes and steaks and eggs and things of this nature. You know, she wants to live the lavish life while she's in jail. Just like R. Kelly. They want to be treated like they are someone of importance. Yous are now officially convicted felons. Neither one of you are of any importance anymore. You are now a regular human being. How about that? We need to take you guys who are way up there on a pedestal and knock y'all down a couple of inches so you can come to earth. Come down to earth. Come down to earth. It's ridiculous. Do the arguments is that she should get less time because jail has been uncomfortable. Right. Right, Just V. So, according to the probation investigators, right, the ones that do the PSI investigations, the pre-sentencing investigations, they want to give her, they're saying that 20 years is good for the guidelines for Miss Maxwell. According to the sentencing guideline, right? But the government wants her to do 55 years in prison. So they're taking off 10 years. Instead of her getting 65, she's getting 55, right? So they decided to do that. But now it's a lot of, back and forth with trying to get leniency for her, like R. Kelly, right? So let's see what else you guys are saying. Is this a sex offender script? I don't know, Indigo, but it looks like they're all copying from each other. I can't wait for the 29th. I took off work. Yes, girl. If you're in New York, maybe we should meet up, Tom Bella. It ain't the country club. Right, Ty. It is not the country club. I don't know what these people expect. I don't know what they were expecting when they went into jail. They watched too many goddamn movies. I mean, come on now. Yes, she's uncomfortable. Robert, yes. Right. Well, imagine how those young girls felt. Exactly. They were uncomfortable in the R. Kelly situation and in Miss Maxwell's situation, aka with Jeffrey Epstein. After last night, I actually thought everyone blocked me. I spent the whole... Oh, girl. They want them to build a separate jail for them, like Escobar had. Right, like what? I don't know what planet Earth they live on, but in the United States of the America, we don't do that. At least he's getting his drawers washed. I mean, he don't have to wash his own drawers. At least that, you're right. Okay. Okay. They are not playing with these sex rings. Exactly. I just cleared my work schedule also. Awesome, Mertice. If you guys are in New York, let me know. Hit me up. If you guys really did take the day off for the 29th and you are in New York, hit me up so we can meet up in Brooklyn. Come on, y'all. Let's get it together. Let's get it together. Let's get it. Let's get it. It's only next week. But guys, if you can and you are able to come to New York, let's go. Let's go. Let's go. Let's show support for these girls. I don't want to be the only one there. Or Blade. Or Warrior. I don't know if Warrior is still having issues with coming down. She might be. I hope she can come down. If they did not want to go to prison, they should have not committed crimes. Exactly. Okay, I'll be working and watching. Okay. All devices on. Who's bringing the dip to the party? I make a great onion dip. Okay, I'll bring the dip. I'll bring the onion dip. Somebody else could do the guacamole and the salsa or something. Or the cheese dip. Sex offenders do not get special privileges other than being protected from general population. Inmates look at sex offenders as the lowest form of life. Facts. You're too far. Okay. Right, like if you, whoever is surrounded by the 5 boroughs of New York, you know. Thank you, SK Mom. I love you too, boo-boo. Love you too, Mama. I will, baby. I will. I gotta get my dip game up. I'll bring the guacamole. All right, and I'll bring the chips and the onion dip. Yes. Damn, the dip. They're going to need a lot of tissues. Did those girls get treated lavishly? I don't think so. Exactly, let's admit. Exactly. Just because Jeffrey Epstein sent them to trips around the world or took them across the country in planes and, gave them $200 here and there and paid for certain girls' educations here and there. And because R. Kelly bought the girls bags and gave them $5,000 allowances does not mean that they were living lavishly. Okay? That was all just a cover up to shut them the fuck up. That's all that was. Okay? Let's get that right. Yes, they do need physical support. Yes, they do, Mama. Keller, okay, Keller, good with them wings. All right, sis. Killer, we need the wings, Killer. We need regular wings, super hot wings, barbecue wings, buffalo wings. Yeah. We need all those kind of wings. Garlic wings. Yup. I wish I could have to come to New York for the sentencing, but I knew I wouldn't be focused that day. That's why I took off. I'm in Atlanta. Oh, okay, Mama. Okay. They got to get their own tissues and antidepressants. He gave them things, then took them away. Girl. None of these girls were able to leave with the shit they got from R. Kelly. They left with the shit they had on their back. Simple. Punto. And if they were smart enough to put a fucking bank account and stash the money that R. Kelly was giving them, then they walked away with money. If not, they ain't walk away with shit. R. Kelly ain't do shit. So, all right, let me stop sharing my screen. She said, who's bringing the bullhorn? I mean, tissues. All right, guys, let me share my screen. Let me get my water, too. Let me get my water. Okay, give me 1 second, guys. I'm going to have to step off the screen for a second because I got to go to my daughter real quick. Give me one moment, okay? Okay, guys, sorry about that. Had to step off for a second, deal with the child for a moment. Sorry, my children come first, guys, you know. Speaking of children, I had a great time yesterday at the Hamilton play. It was really, really a lot of fun to watch in person because I've seen it on the Disney Channel, you know, and I enjoyed it. And I told my daughter about it. And once I told her about it, oh my God, she got addicted. This girl said she watched the show on Disney 136 times, guys. Okay? But she enjoyed it. Hello to everyone that's walked into the building. Hello, hello, hello. Good afternoon, guys. Good afternoon. We're about to get into the reading now. Let me get to the now you know I'm gonna go off screen. Okay. I think I pressed the wrong one. Okay. So this sentencing memorandum on behalf of Miss Maxwell was filed on June 15th of 2022. Okay. All right. It says that 240 months, by the way, guys, is 20 years, I believe. It was 20 years. 240 months is 20 years. So when you hear 240 months, that's 20 years. Okay. So on behalf of our client, Ghislaine Maxwell, we respectfully submit this memorandum in connection with sentencing, which is scheduled for June 28th, 2022. As set forth below, we request that the court grant Ms. Maxwell a significant variance below the advisory sentencing guidelines range of 292 to 365 months and below the 240-month sentence recommended by the probation department. So the probation department, like I said, is recommending 20 years. Okay. Like the probation department is recommending 10 years for R. Kelly, right? Right? Is that what it was? The probation department was looking at 10 years. Ms. Bonjean was asking for 14 to 17, but the government says 25 plus to life, right? Okay. So Ghislaine Maxwell stands before the court because of her association with Jeffrey Epstein decades ago in the 1990s and early 2000s. Never before that time and never again in the roughly 20-year period since the conduct underlying this case occurred has Miss Maxwell ever been accused of a crime, much less a scheme to sexually abuse minors. The witnesses at the trial testified about Miss Maxwell's facilitation of Epstein's abuse, but Epstein was always the central figure. Epstein was the mastermind. Epstein was the principal abuser. And Epstein orchestrated the crimes for his personal gratification. Indeed, had Maxwell never had the profound misfortune of meeting Jeffrey Epstein over 30 years ago, she would not be here. Well, I mean, she wouldn't be there even if she met him, if she just didn't do the stupid shit. Even if she met him. That's no excuse. Epstein avoided a significant sentence when he was first prosecuted in Florida for these offenses, and then evaded any further punishment by dying a month after his arrest and detention in New York. But this court cannot sentence Miss Maxwell as if she were a proxy for Epstein, simply because Epstein is no longer here. Ms. Maxwell cannot and should not bear all the punishment for which Epstein should have been held responsible. Yeah, she deserves all the punishment like Epstein. Why? Because all that time she was complicit, aiding and abetting him, recruiting girls, and abusing them, all in the name of Jeffrey Epstein, because she wanted to make him happy. She didn't have to. She could have left him and reported it and said, listen, this guy's a creep. You need to take him off these streets. Let me tell you why. She ain't do that. You just as responsible as he is. Get the hell out of here. Miss Maxwell has already experienced hard time during detention under conditions far more onerous and punitive than any experienced by a typical pretrial detainee. Girl, you was walking a sweet cake line in there. Okay? You was good in there, girl. And people who commit crimes, there's crimes within the jail. I mean, girl, what did you think you was? Paradise Island? So, and she is preparing to spend significantly more time behind bars. Boo-hoo. Her life has been ruined. Boo-hoo. Since Epstein's death, her life has been threatened, and death threats continue while she is incarcerated. It would be a travesty of justice for her to face a sentence that would have been appropriate for Epstein. In its final pre-sentence investigation report, the PSR, probation recommended a sentence of 240 months imprisonment, a slight downward variance from the sentence recommended by the advisory guidelines. We have submitted objections directly to probation, which are amplified in any accompanying submission. We respectfully submit that in light of the circumstances discussed below, including extraordinary punitive conditions of solitary confinement and the ongoing COVID-19 pandemic, a sentence below the 240 months recommended by the probation would be sufficient, but not greater than necessary to achieve the objectives of sentencing articulated in the 18 U.S.C. 3553A. The context of the case. This is not the first time the events in this case were investigated and resolved. This case is a rival of a prosecution commenced in the Southern District of Florida against Epstein, which resulted in a state court conviction pursuant to a non-prosecution agreement. Now, the plea and sentence were negotiated without notice to Epstein's victims. Also known as the sweetheart deal, created an uproar among his victims and the public, which was fueled by and featured in ongoing coverage in the Miami Herald. The public outcry led to removal of Alexander Acosta from his cabinet post as Secretary of Labor for his role as U.S. Attorney for the Southern District, Florida, overseeing the Epstein prosecution, and to investigate by the Justice Department, the DOJ, Office of Professional Responsibility. Now, in the footnotes, it says that most recently, an inmate in Miss Maxwell's unit threatened to kill her, claiming that an additional 20 years incarceration would be worth the money she'd receive for murdering Miss Maxwell. You know, I think that that's what happened with Epstein. I think he was killed and somebody was paid to kill him. I believe that. I believe that shit. Somebody got paid to kill him. Yes. And the government is covering it up somehow, some way, or something to that nature. I'm not going to go on conspiracy theories, but I don't know. It's kind of fishy, right? Then it says that in the PSR at pages 46 through 63, or maybe paragraphs, not sure exactly which ones to go by there, and the accompanying memorandum of Ms. Maxwell in support of her objections to the pre-sentencing investigation report, they were filed separately. Okay. Now, at the urging of civil attorneys representing Epstein's victims, the U.S. Attorney's Office for the Southern District of New York took the extraordinary step of resurrecting the decade-old case against Epstein. So the SDNY's focus was always on righting the wrongs resulting from the Florida prosecution. Now, Epstein was undercharged and underpunished. Epstein never faced his accusers, and his accusers were denied justice. Epstein was the target and the focus of the prosecution until his death in the custody of the Bureau of Prisons in August of 2019. Now, Epstein's 2019 arrest and aftermath. On July 6, 2019, Jeffrey Epstein was arrested in connection with this SDNY indictment. He was detained in the Metropolitan Correctional Center, the MCC, until his untimely death in custody on August 19, 2019. The highly publicized announcement of his arrest and detention came as a relief and vindication for women who had filed complaints against him. His capture and confinement gilled public outrage at Epstein's lenient Florida plea deal from October 2007 and the low sentence he received. Epstein's death approximately 1 month after his arrest eliminated any prospect of a trial. Again, shocking and disappointing his accusers. It has also highlighted the failure of the United States government to ensure that an inmate in federal custody in such a sensitive and high-profile case could be kept safe and alive to face trial. In the face of strong media and public uproar, following Epstein's death, the government faced an urgency to appease the renewed distress of Epstein's accusers and to repair the tarnished reputations of the DOJ and the BOP in whose custody Epstein died. There would be no trial for Epstein and no public vindication and justice for his accusers. The government now had a huge hole to fill: Epstein's empty chair. Although four women had been specifically named as co-conspirators or accomplices of Epstein in connection with his controversial Florida plea deal, and although 3 of those same women were anonymously referenced in the 2019 Southern District of New York indictment charging Epstein, the government chose not to prosecute any of them. Instead, the spotlight turned to Miss Maxwell, with whom Epstein had a relationship that was long since over and who was not named in the Florida sweetheart deal. That was a lie. Didn't they say in a deal somewhere that to leave Miss Maxwell and the royal guy alone, Mr. Andrew. Wasn't there somewhere a stipulation somewhere along those lines that Jeffrey Epstein did some type of side deal and said, listen, these people, leave them alone. Don't touch them. Don't you remember that? I think that's what happened. That's strange. I don't know about all that. So, Ms. Maxwell did not appear in the 2019 Southern District of New York indictment against Epstein, nor was she the subject of the 2007 Southern District of Florida grand jury presentation. Nevertheless, the government pivoted to Ms. Maxwell. So who up to that point had never been the focus of any criminal prosecution for these events, and spent the next year investigating her. In doing so, SDNY had to reach back to events that were over 20 years old, a decade before the conduct that was the subject of the SDFL prosecution and the 2019 Epstein indictment. Almost a year to the day after Epstein's arrest, Southern District of New York's acting U.S. attorney put the timing of Ms. Maxwell's prosecution and the extreme age of the charges against her in context. And this is what it said. We were working hard on this investigation this past year. It's not easy to put together a case that goes back that far, but it was nothing other than we did the investigation and we were ready at this time to proceed. So the entire focus of the accusations initially aimed at Epstein were now centered on one defendant alone, Ms. Maxwell. Ms. Maxwell, at the time when she was already being vilified in the press and the public domain, the media coverage was relentless and voluminous. Dozens of broadcast documentaries, tens of streamed videos and podcasts and publications of some 50 books, and thousands of superficially written articles. The tsunami of one-sided, overwhelming negative coverage about Ms. Maxwell that followed the arrest and death of Epstein presented Ms. Maxwell as a caricature of evil, a depiction that has inevitably shaped the public's opinion of her. And the government added to demonization of Miss Maxwell by calling her a villain on the day of her arrest. But in sentencing Miss Maxwell, the court cannot be influenced by this inexorable drumbeat of public condemnation calling for her to be locked away for good. The court cannot heal the wounds caused by Epstein by heaping on Miss Maxwell's shoulders the pain of every one of his victims, the outrage of society, the public scorn of the community, and then driving her out of the community forever. While that may assuage the public and give the perception that justice was done, that is not justice. That is scapegoating. Miss Maxwell must be sentenced on the record before the court and not these external pressures. Now they're going to go into Miss Maxwell's arrest and her detention. So at dawn on July 2nd of 2020, a team of more than a dozen FBI agents arrested Miss Maxwell at the New Hampshire home where she had taken refuge after Epstein's death to escape the upsurge of highly intrusive media coverage that had engulfed her and her family. She had relocated alone, separating from her family to safeguard her husband and two young stepchildren, and to secure the personal safety of her family and herself. At that time, Miss Maxwell was the target of numerous death threats and threats of violence and was being hunted by the press. One media outlet even offered a $10,000 bounty for information about her whereabouts. Tragically, this experience was not new for Miss Maxwell. Decades earlier, when Miss Maxwell was just a child and her father was a member of parliament, the United Kingdom authorities found a hit list of potential kidnapping / assassination targets in a safe house used by the Irish Republican Army. Miss Maxwell's name was first on. Oh, hold on a second. Okay, sorry about that, guys. Okay, so Miss Maxwell's name was first on the list. This unnerving, hey, get out. No, Tiger. Shh. Get away from the book. Sorry about that, guys. My kitty was trying to go out. Okay. Tragically, this experience was not new for Miss Maxwell. Decades earlier, when Miss Maxwell was just a child and her father was a member of the Parliament UK, authorities found a hit list of potential kidnapping assassinations targets in a safe house used by the Irish Republican Army. Ms. Maxwell's name was first on the list. The unnerving experience has haunted her, heightening her vigilance and concerns about the welfare and safety of her young stepchildren, who were being hounded by the media at school and at the beach, and her husband, who was besieged by media coverage and had lost his employment and professional relationships. Ms. Maxwell was also worried for herself, having legitimate reason to fear for her own life. Despite having the benefits of foreign citizenship, Ms. Maxwell, a naturalized American citizen, remained in the United States consistently after Epstein's death, never evading the authorities. At the time of her arrest, Ms. Maxwell was not considering flight, even though, given her French and British nationalities, she could have taken refuge in these and other countries at any time. Law enforcement had been discreetly keeping tabs on her throughout the course of its investigation. Her lawyers had been in contact with prosecutors in the months preceding her arrest and would have arranged for her self-surrender. Miss Maxwell's presence in New Hampshire was driven solely by the need to protect herself and her family from threats of physical harm and from the unprecedented and escalating press and public vilification she had to endure since Epstein's death. Give me a second, guys. On July 6, 2020, exactly a year to the day after Epstein's arrest, Miss Maxwell was ordered detained in the Metropolitan Detention Center based on the government's assertion that she posed an extreme risk of flight and that no condition or combination of conditions will reasonably assure the appearance of the defendant as required. Each of 4 bail applications were denied on the elusive claim of flight risk. Despite the unprecedented financial collateral and restrictions proposed to secure a hefty bond for an almost 60-year-old woman who the government conceded posed no danger to the community and who had never attempted to flee the United States. For the next 22 months, she was exposed to discriminatory and punitive solitary confinement, isolated from all other inmates, and subjected to abnormally rigorous conditions. On April 20th of 2022, almost 4 months after trial, she was abruptly placed in general population, and the charade of her pretrial detention was revealed. Her unusual detention was intended to help redeem the DOJ and BOP reputations tarnished by Epstein's untimely death in custody, and to ensure that Epstein's accusers would have their day in court. Ms. Maxwell's pre-sentence detention was tantamount to pre-sentence punishment. Nor will Ms. Maxwell's disproportionate pre-sentence punishment end now that she is in general population. Just recently, Ms. Maxwell was the target of a credible death threat from a fellow inmate. On information and belief, one of the female inmates in Ms. Maxwell's housing unit told at least 3 other inmates that she had been offered money to murder Ms. Maxwell and that she planned to strangle her in her sleep. The inmate who made the threat has been moved to the SHU, presumably to protect Ms. Maxwell. This incident reflects the brutal reality that there are numerous prison inmates who would not hesitate to kill Ms. Maxwell, whether for money, fame, or simple street cred. Ms. Maxwell has effectively traded the stress of flashlight checks every 15 minutes in the middle of the night while in isolation for the equivalent stress of having to sleep with one eye open. For as long as she is housed with other inmates, Ms. Maxwell will have lived with this threat every day that she is housed in the MDC and every day that she is incarcerated in the prison where she is designated. I mean, you're a predator. What more did you expect? What more did you expect, Miss Maxwell? You're not R. Kelly, that's for sure. So I don't think you could sing your way out of protection. Like, R. Kelly got a gift. He got a gift of gab, and he got a gift of them lungs and that voice he got. So he could sing his way out of things. Maybe. In the meantime, it's getting him somewhere. He's doing good. Now, they're going to talk about the offense conduct. Now, having ruled on extensive pre- and post-trial motions and having presided over the jury trial and the post-trial hearing regarding Juror 50, the court is fully familiar with the record in this case. Now, we're going to talk about the pre-sentence investigation report. So now, on June 9th of 2022, Probation filed its final PSR recommending a below guideline sentence of 240 months imprisonment. As I said, 240 months is 20 years. So that's what the probation filed to recommend for her conviction of 20 years. So, and it's also followed by a 5-year term of supervised release. So she'll get 5 years probation, supervision probation. So regarding a sentencing recommendation, probation has identified several mitigating factors. Maxwell is 61 years old. and a guideline sentence may be tantamount to a lifetime term of imprisonment. The defendant has a reported history of philanthropy, charitable work, and helping others, namely her work with the Clinton Global Initiative, the Terra Mar Project, her use of EMT skills to help others, and her tutoring of inmates at the MDC. We further acknowledge that Maxwell is not solely responsible for the horrendous and irreparable damage caused by the decade. So the probation people were saying, she's 61 years old. Whatever you guys give her, it's basically almost like a life amount of sentencing. And she's done a lot of charity work. And she's helped others as an EMT. She even worked with the ex-president. Now that she's in the MDC, she's been tutoring inmates. I want to know what R. Kelly has been doing. I want to know the good things that they got to say about R. Kelly. What did they say to recommend a 10-year sentencing for him? So and they were also saying that because she's not the sole bearer of all this drama, it's Epstein too, she shouldn't be so condemned. Oh my goodness gracious. Now they're going to talk about the adjustment to incarceration. Now, despite her extraordinarily restrictive conditions of detention, Miss Maxwell has availed herself of any programming or work opportunity available to her. While in solitary confinement, she completed 6 courses, but until transferred to general population, she never had the opportunity to make use of that training. So post-trial, she was permitted to work as an orderly, which has continued in general population. So since placed in Gen Pop, she has eagerly provided a wide variety of assistance to the women in her unit, including GED tutoring. And it talks about that in the pre-sentencing report, paragraph 16. In addition, she has participated and completed several education courses. See the PSR report at section 15. Now, Ms. Maxwell is planning to appeal her conviction following her sentencing. Accordingly, any discussion of the trial evidence in this submission is not an admission by Ms. Maxwell as to its accuracy or veracity. Now, we're going to talk about Ms. Maxwell and her personal circumstances and characteristics. Ghislaine Noel Marion Maxwell was born December 25th, 1961, in Maisons, Lafayette, France. The last child born to the marriage of Robert and Elizabeth Maxwell. She is youngest of 9 siblings. A sister died of childhood leukemia years before Ghislaine was born. 2 days following Ghislaine's birth, her eldest sibling, Michael, was seriously and permanently injured in a car accident. He remained in a coma, on and then off life support for the next 7 years. So we're going to find out about her family tragedy and controversies. So the tragedy caused by Michael's accident and coma disrupted the equilibrium of the Maxwell family and transformed young Ghislaine's formative years. Ghislaine was hardly given a glance and became anorexic while still a toddler. At age 3, she stood in front of her mother and said simply, "Mummy, I exist." On doctor's orders, exactly a year after Michael's accident, her mother went on a long tour of India and Australia, leaving infant Ghislaine and her siblings not already in boarding school at home in the care of a nanny. With Robert Maxwell's publishing company growing and his political career launched, the Maxwell home was filled with prominent guests and ongoing entertaining. As the children grew, they took part in the hosting of guests, having been instructed by their parents to be attentive to the needs of the guests. Despite Mr. Maxwell's professed love for his children, his relationship with them began to change soon after he became a member of parliament. He stopped living at home regularly, essentially seeing the children only on Sunday, leaving little normal daily contact between father and child to counterbalance the peaks of crisis and drama he created in the family. Even on those Sundays, there was an inevitable contingent of authors and business people in whose presence the children would, so to speak, be put on trial, and the Maxwellian drama would begin. So in the footnotes here, it says that the following discussion amplifies information, contained in the PSR at 134 through 178 paragraphs. Now, this section is corroborated by the autobiography of Ghislaine's mother, Elizabeth Maxwell, called A Mind of My Own, written by HarperCollins in 1994. So the ordeal occurred every Sunday at lunchtime. The conversation would start normally until Mr. Maxwell selected one child to answer his questions on a particular topic in accordance with the rules of life he has encapsulated into mnemonics and drilled into them. The 3 C's: concentration, consideration, and consciousness, or WWWH: what, why, when, and how. If the child stumbled, didn't speak on point, or gave a wrong answer, Mr. Maxwell would demand them to answer which of the principles they had forgotten to apply and the reason for that failure. The dressing down was always painful in the extreme, with everyone around the table feeling uncomfortable. Mr. Maxwell, a man of large physical stature with a booming voice, would explode, threaten, and rant at the children until they were reduced to pulp. Mr. Maxwell was relentless, with children ending up in tears, punishments being doled out, and the whole family in utter distress. Mr. Maxwell employed corporal punishment on his children. Ghislaine vividly recalls a time when, at the age 13, she tacked a poster of a pony on the newly painted wall of her bedroom. Rather than mar the paint with tape, she carefully hammered a thin tack to mount the poster. This outraged her father, who took the hammer and banged on Ghislaine's dominant hand, leaving it severely bruised and painful for weeks to come. He banged her hands with a hammer. What kind of a father is that? What What the hell? Out of the home and off to boarding school. So this is another part of Ghislaine Maxwell's life that was spoke about, in the PSR report. Within a week after Ghislaine's 17th birthday, Michael, her brother, right, then 23 years old, he died, further disrupting the family. By age 8, Ghislaine was sent off to boarding school at a time when it was uncommon for girls, let alone girls of primary school age, to be boarded. The school was hours away from home, and she returned only during school holidays and at the end of the school year. Mr. Maxwell's political career was ending, and he would face the loss of his publishing company, a continuous takeover battle, and legal investigations that would blight the family for the next 7 years and permanently damage his reputation. The 1970s were difficult and demanding years for the family, marred by Mr. Maxwell's endless battle of lawsuits and financial ruin. Despite the family chaos, Ghislaine thrived in boarding school, away from the whirlwind of emotional turmoil caused by the relentless demands of her father, which continued until his death in 1991. Then it's going to speak a little bit of her being on her own. Now, Robert Maxwell demanded much of his children and informed them that they needed to keep industrious, as they would not be receiving any inheritance. Hardworking, entrepreneurial, and resourceful, Ghislaine excelled academically and occupationally. Between finishing her A-levels at Marlborough College and attending Oxford University, she spent a year in Spain teaching English, then selling books for her father's publishing company in France. She began her first romance only to have the relationship squashed by her father's disapproval of her engagement. A family reconciliation coinciding with Ghislaine's 20th birthday devolved into a miserable Christmas. Mr. Maxwell was at his absolute worst, making Ghislaine the scapegoat du jour. The holiday ended with an announcement that her parents were separating. While attending Oxford, she started a booster club, which made discount tickets to sporting events available to students, and participated in an organization which provided services to the elderly. After receiving both bachelor and master's degrees from Oxford University, Ghislaine worked at a temp agency and started her own company, Maxwell's Corporate Gifts. That was the name of her company. At her father's insistence, the business was merged into his business holdings. So by 1991, Ghislaine had relocated to New York to launch the European, which is an international magazine, as part of the Maxwell Publishing conglomerate. Within that year, Ghislaine's father died under suspicious and unresolved circumstances and under a cloud of business impropriety. With Mr. Maxwell deceased, her brothers, Ian and Kevin, employees of their father, shouldered the accusations. All family assets were frozen. Elizabeth Maxwell was left penniless. The brothers were tried and ultimately acquitted, and Ghislaine was left to fend for herself. Now it's going to speak about life after Epstein. So in 2003, Miss Maxwell began a 7-year romantic relationship with Theodore Ted Waite and developed a strong and loving bond with his 4 children, ranging in age from 6 to 12. Her relationship with Waite was on track for marriage and gave her what she had always hoped for and wanted most: the opportunity for a loving, stable family life and the chance to become stepmother to Waite's children. But her hopes were destroyed, as was so much of her life, by her previous association with Epstein. A Miami lawyer named Scott W. Rosenstein, Esquire, attempted to blackmail Waite to keep Miss Maxwell's name out of civil lawsuits related to Epstein that his law firm was planning to file. Miss Maxwell's relationship with Waite could not survive the blackmail threats, and it ended soon afterwards. The same thing has now occurred again several years later as a result of this prosecution. So in 2013, Miss Maxwell began a new relationship with the man she would later marry. She was with her husband for over 7 years and became a devoted stepmother to her husband's 2 youngsters, who were ages 3 and 4.5 at the start of her relationship. Sadly, the marriage could not survive the negative impact of this case, nor a husband's association with his dishonored wife. Okay. Let me see something. Oh, okay. Now, in the footnotes over here, it says that it was around the time that Miss Maxwell met Jeffrey Epstein for the first time. As Miss Maxwell plans to appeal her conviction, we will not comment on the events during the time period that were the subject of the trial. Now, through his law firm, Rothstein, Rosenfeld, Adler, RRA, perpetrated a massive $1.2 billion Ponzi scheme in Florida, touting RRA as the preeminent sexual harassment firm in the country. Now, Rothstein claimed to be representing numerous underage girls who had been involved with Epstein. Now, in the spring of 2009, RRA recruited Bradley J. Edwards, Esquire, who immediately joined the firm. By the end of October of 2009, Rothstein became a fugitive and later returned to face arrest, to plead guilty to RICO charges in the Southern District of Florida, and to receive a 50-year sentence. So that lawyer was doing a Ponzi scheme, and he got arrested. And he received a 50-year sentence for that. So Rothstein had targeted Waite, which was Ghislaine Maxwell's boyfriend at the time, right? The deep pocket co-founder of Gateway Inc. Oh, so he was a deep pocket co-founder because of his ongoing relationship with Miss Maxwell, who had previously been involved with Epstein. Rothstein demanded $10 million to keep Miss Maxwell's name out of civil lawsuits. Now, Waite successfully resisted Rothstein's blackmail attempt, but Miss Maxwell was named in lawsuits filed by RRA. So ultimately, Miss Maxwell's relationship with Waite did not survive the ordeal. And it talks about this in her pre-sentencing report. So Miss Maxwell has always worked hard. Her many educational, occupational, and avocational accomplishments include becoming an emergency medical technician, a helicopter pilot, a submersible pilot. Oh, she knows how to ride a submarine? Or submersible. A submersible pilot. A banker, partnering with the Cleveland Clinic to establish a telemedicine platform to enable people in remote areas to obtain quality medical treatment, helping develop the Clinton Global Initiative. and supporting a variety nonprofit and charitable organizations. In 2012, at age 50, she turned a lifelong passion for the oceans into a nonprofit environmental organization, the Terramar Project. Now, with the mission of creating a global ocean community based on the idea of shared ownership and responsibility of global commons, the high seas, and international waters. She spoke on topics related to ocean conservation, giving TED Talks, and delivering a speech at the United Nations. National Geographic and Oxford University were among the organizations that collaborated in support of the project. Now, the Terramar Project was closed after Epstein's death to spare her partners from invasion of privacy by the press due their association with her. And it also talks about this in the PSR report. Now, there are also letters from family and friends. Now, accompanying letters from family and remaining friends, most having cut ties due to fear of association and the lure of cancel culture. Attest to Ghislaine's character. Each offers a first-person narrative of some aspect of her life, in sharp contrast to her characterization as a villain, rich heiress, and vapid socialite. See Exhibits A1 or AI. A through I. See Exhibits A through I. Now, her eldest sibling and half, a psychotherapist, and Philip Maxwell recount the impact of their father. Now, in her relationship with Epstein began at a moment of extreme vulnerability. Ghislaine's life after the tragic death of our father, our father, was a powerful and dominant figure. And as elder siblings, we witnessed our father taking Ghislaine under his wing, whereby she became over-dependent on his approval and vulnerable to his frequent rapid mood swings, huge rages, and rejections. This led her to becoming very vulnerable to abusive and powerful men who would be able to take advantage of her initiate good nature. It is striking that Ghislaine did not show any perverse behavior before she met Epstein, nor did she show any after leaving him, which was eventually managed to do so. The effect of our father's psychological abusive treatment of her foreshadowed Epstein's own ability to exploit, manipulate, and control her. Exhibit A. Another psychotherapist and family friend of some 55 years, James Martin Holloman, recalls his observations of Ghislaine's father. Their father was narcissistic, demanding, and highly controlling. He let them know early that he was going to leave his large fortune to charity. So all the kids knew they had to make it on their own, despite the wealth and privilege in which they were growing up. As I got to know each of these kids, including Ghislaine, I noticed that early on, every single one worked very hard at their jobs. As Bob wouldn't bear any idleness, and each strove for their father's and mother's respect through their intelligence and their own hard work. Now, Exhibit B, there is her twin sisters, Christine Molina Maxwell and Isabelle Maxwell. They attest to Ghislaine's work ethic. And in there it says that we were privileged, but we were not entitled, and life was not always perfect. Unfortunately, our family also became a grieving family. Our oldest brother, Michael, was gravely injured in a car accident just after Ghislaine was born. He remained in a coma until his death when Ghislaine was 7 years old. In spite of his tragedy, I watched Ghislaine learn to adapt and to become a productive and caring human being. Both of our parents had an incredible work ethic. We were all encouraged from an early age to work to earn money and to respect the responsibility that came with the privileges. I have witnessed that work ethic in Ghislaine. Ghislaine had many Ghislaine had money because she worked very hard to earn it. Her positions demanded hard, diligent work, great intelligence, great management skills, great ability to get on well with people from all walks of life, artistic creativity, and caring about others. Her work was a far cry from the flippity jip socialite label that the media has decided to cast on her every time they reference her. Now, Exhibit C, from a very early age of us, had to learn and demonstrate what our father termed the 3 C's: consideration, concentration, and consciousness, and to always treat others as you would like to be treated yourself. We were quizzed on these principles constantly and had to regularly report examples of how we followed them. Ghislaine was no exception in deeply absorbing, exhibiting, and living these values. For example, I think it is no small feat to train and become a helicopter pilot and emergency medical technician, submersible pilot, and more, as they all require dedication, concentration, and quick thinking and reactions, and no small amount of courage. My sister was also very entrepreneurial in creating and investing in multiple companies and organizations, which created products and services, as well as employment. An important example is that in 2012, Ghislaine turned a lifelong passion for the oceans into a nonprofit, the Terra Mar Project, with the mission to create a global ocean community based on the idea of shared ownership and responsibility of the global commons, the high seas or international waters. Now, Exhibit D is her brothers, Ian and Kevin Maxwell. They confirmed the support Ghislaine has provided to others. So now remember, we're talking about her character references, her letters. These are the character reference letters, okay? So these are the kind of things that we're going to see happening in R. Kelly's PSR report as well. You know, certain types of things. These are the certain types of things that are going in this report, that went in this report, so that the judge can rule, you know, according to everything overall. So her brothers, Ian and Kevin Maxwell, confirmed the support of Ghislaine and has provided to others. Now they say, my sister is aunt to 13 nieces and nephews, now aged 18 to 37. And I have witnessed at first hand over the years her generosity to them, be it paying their school fees, mentoring them, and they grew up on providing job opportunities for them. She also has an enduring capacity for friendship, a warm heart, and the ability to convert those feelings into action when required to help those less fortunate than herself. She had discreetly supported some friends and financially, and others by providing a roof over their heads when they were down on their luck, often for weeks at a time. Then Exhibit E, her other brother's letter. Ghislaine is an intelligent, warm-hearted, generous, kind, funny, thoughtful, and loving person. She cares about others. Ghislaine's first reaction on hearing of a problem is how to solve it or how to contribute to a solution. Her desire is always to engage, to bring energy to every problem, and to help. Exhibit F. Yeah, you know, she did help. She helped Jeffrey Epstein to procure girls for his sexual gratification. Yeah, you're right. Yeah, she has a desire to always help. Right. Exhibit F, Catherine Von Edwards, a friend, a former employee, and the mother of Ghislaine's godson, relates to her experience as a mentee. Hold on. Hold on a minute. We have a letter here from a mentee. You know, Levi, Dana, Sharon, they should all write a letter. They all know R. Kelly personally. They should. They can. As we can see here, they can. Those three people should write a letter of character reference for R. Kelly because they know him. One was a mentee, one is a cousin, and the other one worked for him for a year. She was with the family, with his children, with his wife, with him as well. So I hope Sharon, Levi, and Dana do write letters. I hope you guys write. I hope you wrote letters. Hurry up, write them and send them in before his sentencing next week. See if you could get it in. Or if not, I hope you already did that because you know him so well. You want leniency for him. Show and prove that you know him. Show and prove that you know him. Show that you know him, that you love him, that he's helped you out. Levi said that he's helped them out financially. Let the courts know what he did for you. Dana, he helped you with college. Go say something. Write a letter. Sharon Winbush, he helped you build up your career. You were with his children, feeding them, giving them nutritious meals, talking to them, I guess, being their friends, right? All of y'all know him, right? Write those damn letters then. I want to see them. I want to see those letters. Woo! I want to see those letters. Okay, so Catherine Von Edwards, a friend, former employee, and the mother of Ghislaine's godsons, relates her experience as a mentee. She says, the person that I have known for 34 years is not the same as the Ghislaine so negatively portrayed by the press and mainstream media. My own experience is that she is kind, caring, and thoughtful, and is always there to provide support as a loyal and generous friend. She has been a mentor, encouraging and helping me to develop my business, and gives her time and advice freely. See, Dana could write a letter like that. Yeah, Levi could write a letter like that. Why not? Why not? Exhibit G. And finally, Harriet Jagger, a schoolmate from age 15, shares Ghislaine's longing for a family life. The last time I saw Ghislaine was in her home in New York a few years ago. I listened to her as she spoke of her wish to find the security and happiness within a family unit. She was visibly upset that this the simplest of things for so many others had still not been a part of her own life. I felt truly sorry for her, having known her large and great family, her love and great respect for her parents, and closeness to her brothers and sisters. I knew this was something she had always craved. I gave her a hug, a huge hug, on departing. So I was then thrilled to learn that she had finally met and married someone and was helping bring up his young children. But them desperate to hear that this much sought after joy was so short lived. Exhibit H. Exhibit H. A non-guideline sentence would be sufficient but not greater than necessary to achieve the goals of sentencing. So, advisory sentencing guidelines. As the Supreme Court has repeatedly explained, a direct court should begin all sentencing proceedings by correctly calculating the applicable guidelines range. As a matter of administration and to secure nationwide consistency, the guidelines should be the starting point and the initial benchmark. After correctly calculating the guidelines range, the court must next consider the statutory factors set forth in 18 U.S.C. 3553A. As directed by the Supreme Court, a district court may not presume that a sentence within the applicable guidelines range is reasonable. Rather, after calculating the appropriate guidelines range, sentencing courts must consider the 3553A factors, make an individualized assessment, and impose a sentence that is sufficient but not greater than necessary to meet the objectives of sentencing. Okay. Now, under the 18 United States Code, sections 3553A. Let me take a sip of water, y'all. Okay. Now, the 3553A factors include, among other things, 1, the nature and circumstances of the offense and the history and characteristics of the defendant. 2, the need for the sentence imposed, which would be A, to reflect the seriousness of the offense, to promote respect for the law, and to provide just punishment of the offense. B, to afford adequate deterrence to criminal conduct. C, to protect the public from further crimes of the defendant. D, to provide the defendant with needed educational or vocational training, medical care, or other correctional treatment in the most effective manner. And E, to avoid unwarranted sentence disparities. And 3, the kinds of sentences available. In this case, we respectfully submit that the 3553A factors, including Ms. Maxwell's history and characteristics, the need for the sentence imposed to provide just punishment, and the need to avoid unwarranted sentencing disparities weigh heavily in favor of a sentence significantly below the sentence recommended by the advisory sentencing guidelines and below the sentence recommended by probation. So they stated the same thing in the objection to the PSR report that we read, right? Was it the objection or the government's? One or the other. Now they're going to talk about Miss Maxwell is not a danger to the community. So again, these are the types of things that are in R. Kelly's PSR report. These are the types of things that are in his report that we could not see. Now, I'm glad that Miss Maxwell's wasn't sealed. So I'm giving you guys an example of what the sentencing report from R. Kelly could look like. Okay, I'm just comparing notes. All right. Now, they're going to talk about Miss Maxwell is not a danger to the community. Miss Maxwell poses no threat to the public, and there is no risk that she will reoffend upon her release from custody. The government has never argued in connection with Miss Maxwell's bail application or otherwise that Miss Maxwell is a danger to the community, nor could they. Apart from the conduct at issue in this case, which occurred almost 20 to 30 years ago, Miss Maxwell has never once been accused of a crime, much less sexual abuse of minors. In fact, after leaving Epstein, Miss Maxwell was involved in committed long-term relationships with two men, both of whom had young children who continued to support her. Miss Maxwell is not a dangerous criminal or a habitual offender. She is someone who wants nothing more than to live a normal family life, something she was denied because of her association with Epstein and will now almost certainly never have. The public does not need to be protected from Miss Maxwell, and such consideration should have no weight in determining her sentence. Now they're going to talk about the guideline sentence. A guideline sentence is not necessary to achieve specific or general deterrence. A guideline sentence for Ms. Maxwell would not serve the sentencing goals of either specific or general deterrence. A significant sentence is not necessary to achieve the goal of individual deterrence here. A significant sentence is not necessary to achieve the goal of individual deterrence here. This is Ms. Maxwell's only brush with the law. Ms. Maxwell has already learned the painful lesson from her arrest and prosecution, has lost her marriage and her stepchildren, and has been harshly punished during pre-sentence incarceration. Ms. Maxwell has already shown that she will not reoffend and does not need to be further deterred from committing crimes in the future. Nor can general deterrence be used to justify a harsh sentence for Ms. Maxwell. Probation identifies two groups of potential offenders who will purportedly be deterred from committing future crimes as a result of Ms. Maxwell's sentence. 1. Sexual predators who exploit and degrade minor victims. And 2. Untouchable individuals who feel their privilege and affluence entitle them to victimize others without fear of consequence. The PSR at 67. Now, with regard to the first group, courts have expressed legitimate doubts as to whether people who have a sexual predilection for minors, people who have a sexual predilection for minors can be deterred at all. The compulsive behavior and disorders motivating many offenders is less susceptible to general deterrence. With regard to the second group, the purported justification sweeps far too broadly. Rather than identify a particular class of similarly situated defendants who will be deterred from committing specific crimes. Probation essentially makes the sweeping assertion that a harsh sentence for Ms. Maxwell is necessary to deter rich people from exploiting poor people. Oh, I can agree with that. Mm-hmm. This is not the purpose of general deterrence and should not be given any weight in determining the appropriate sentence. Then they talk about a below guideline sentence would provide just punishment, promote respect for the law, and avoid unwarranted sentencing disparities. So while the offense conduct is indisputably serious, the record reflects that Epstein was the main offender. So given the foregoing decision, discussion, given the foregoing discussion, a shorter term of incarceration for Ms. Maxwell best serves the long-term goals of punishment. A significantly below guideline sentence in this case would also promote respect for the law by demonstrating that the justice system considers each person who comes before the court as an individual. A sentence tailored to Ghislaine Maxwell's particular circumstances would appropriately distinguish between this defendant and more culpable individuals similarly charged, like R. Kelly. Courts must guard against unwarranted similarities amongst sentences for defendants who have been found guilty or dissimilar conduct. In addition, a non-guideline sentence would avoid unwarranted sentences disparities. It would be plainly unjust to sentence Ghislaine Maxwell as if she were Jeffrey Epstein. Had Epstein been tried on this indictment, he would have been exposed to comparable guidelines range. Justice would not be served by sentencing Ms. Maxwell to the extent of the more culpable Epstein, nor should she be sentenced as if she were Harvey Weinstein, following a state jury trial convicting him of forcible rape. Weinstein received a prison sentence of 23 years, less than the lowest part of the guideline range calculated by probation for Ms. Maxwell. Well, Mr. Harvey Weinstein didn't molest or sexually exploit children, minors. He was dealing with women, so that's on another level. Moreover, a non-guideline sentence would at least mitigate the drastic disparity between the penalties under state and federal law in this case. The predicate state offense in counts 3 and 4, New York Penal Law 130.55, is a misdemeanor punishable by a maximum term of 90 days imprisonment. Viewing the conduct of conviction in the light most favorable to the government, imposition of a guideline sentence for Ms. Maxwell will lead to inequitable and disparate I can't say that word, results. I guess they meant to say disproportionate results, right? In this case, the goals of sentencing will be achieved by a significant downward variance from the unduly harsh guidelines range of 292 to 365 months and probation's recommended 240-month sentence for offense conduct that occurred 18 to 28 years ago and where a 60-year-old female defendant with no prior or post-offense history of misconduct requires no rehabilitation by incarceration and poses no risk of recidivism. I guess no risk of doing it again, in other words. Unusual harsh pre-sentence confinement warrants a downward variance. The phantom of the Epstein death fiasco hung over Ms. Maxwell's case and her detention. Throughout this prosecution, Ms. Maxwell's counsel challenged the conditions of her extraordinary detention as being exceptionally prejudicial and unprecedented, most especially for a 60-year-old female with no prior criminal record, who posed no threat to others, has no suicidal tendencies, past or present, and was not charged with crimes of violence. Ms. Maxwell was charged with and convicted of acts allegedly committed 20 to 27 years ago. The treatment meted out to Ms. Maxwell during her 22-month period of isolated detention was unparalleled. From the outset, Ms. Maxwell's conditions of detention were extraordinarily restrictive and unjustifiable in view of her personal circumstances, and were manifestly unreasonable and unnecessary in view of meaningful alternatives available in the MDC. There is no explanation for her extraordinary conditions of confinement other than calculated efforts by the DOJ, BOP, MDC, and prosecutors to prevent other Epstein debacle and to ensure that Ms. Maxwell would fill the chair vacated by Epstein's demise. This assertion is supported by the swift and cavalier transfer of Ms. Maxwell from 22 months of isolation to general population. Ms. Maxwell was subjected to an exceptionally intrusive prison regime, which undermined her dignity, health, safety, and psychological well-being. The following discussion regarding the restrictions adds further texture to allegations concerning her confinement. For 22 months, Ms. Maxwell was segregated from general population, locked in an isolation cell measuring 9 by 7 feet. While confined to that cell, she was restricted from moving out of range or of the camera focused into the cell. Okay, and in the footnotes here, it says that the transfer was made without any notice to Ms. Maxwell's counsel or consultation with Ms. Maxwell, who had been prodded by psychologists daily until the day of the move, notably within the week leading up to Ms. Maxwell's transfer. The MDC asked women in general population how they felt about Ms. Maxwell joining their unit, and no reciprocal inquiry was afforded Ms. Maxwell when it came to a radical change in her housing circumstances. So it continues to say that she was restricted from moving out of range of the camera focused into the cell. During daytime hours, she was isolated in a larger space. At no time did she have contact with any other inmate. She was watched round the clock by a security detail dedicated exclusively to guard her, as she was constantly monitored by video surveillance. Her security detail rotated every 2 weeks and consisted of high-level BOP staffers recruited from facilities outside New York who were instructed to guard a high-profile, high-security inmate on suicide watch. Ms. Maxwell was subject to constantly changing rules and whims. Her only source of information was from the guards who controlled her. They became the source of information regarding rules, regulations, and opportunities. If they chose not to dispense information, or if they provided incorrect information, she had no basis to challenge them. She was instructed not to speak to them, lest she face disciplinary action. Speak to them lest she faced disciplinary action. Such is not the case in general population, where inmates assist other inmates and bear witness to and identify inconsistent and improper treatment. Unlike other inmates, Ms. Maxwell was subjected to various probations. She was prohibited, subject to various things, and deprived, not common to other inmates. She was monitored 24 hours a day by stationary security cameras and by an additional handheld camera that followed her while under the constant surveillance of several prison guards who scrutinized her every move. Even when she was showering and taking notes of her activities and recording them in various notebooks. The procedures in place deprived Ms. Maxwell of any privacy and prevented uninterrupted sleep. The constant illuminance during the night disrupted her, leaving her sleep deprived and causing exhaustion that affected her ability to concentrate. Initially, she was denied adequate and restful sleep by bright lights left on in her cell for 24 hours a day, coupled with the flashlight shining into her eyes or cell every 15 minutes. Now, it says that in the footnote, the cost of her individualized detention should be a great concern to the tax-paying public and warrants an investigation into the propriety of this enormous expenditure for a single nonviolent inmate. Listen, as a tax-paying citizen, I don't care. Do what you got to do to these people. Make sure she don't kill herself. Please and thank you. We want her to face charges. So if you got to go into her cell every 50 minutes and shine a light on her to make sure she alive, oh, well, that's the rules. That's what it is. Throughout the night, when the bright lights were turned off in her cell, bright lights remained on directly outside her cell, and the flashlight checks continued. A regime completely inappropriate for a non-suicidal inmate. This unjustified sleep deprivation, which continued throughout trial and afterward, affected her general physical condition, as well as her psychological well-being. This practice does not exist in general population. Despite never being in contact with any other inmate, under continuous surveillance by prison guards and cameras, and escorted to and from an isolated location, she was subjected to an excessive number of physical searches on a daily basis, pat-down searches, strip searches, body cavity searches. She was unnecessarily exposed to radiation from body scanners and was fortunate not to contract COVID when guards, who were not required to take COVID tests, looked and searched inside her mouth. Her cell was searched multiple times daily. The searches were redundant, unreasonable, unnecessary, and abusive beyond any legitimate penological purpose, especially where Ms. Maxwell had no opportunity to acquire contraband. At times, searches were conducted in inappropriate ways and were especially painful, humiliating, and intimidating, as well as when her breast and genitalia were touched in a rough and reckless manner. Reports by Ms. Maxwell and counsel concerning sexual inappropriate searches by corrections officers went nowhere. It is clearly established that excessive searches are unnecessary and unreasonable when a prisoner is isolated from other inmates and never out of range of the camera or a guard. Ms. Maxwell was searched every time she was removed from or returned to her isolation cell, even when she had no conceivable opportunity, let alone no intention, to obtain contraband. Clearly, the search policy is one that was not applied consistently. Having been in general population for the past 2 months, Ms. Maxwell has only been searched after contact visits with counsel. Because Ms. Maxwell was kept in isolation, she was denied the minimal amenities provided to general population inmates even during COVID, except for programs that she completed but could never put to use in isolation. She was not permitted to participate in general programming, educational, leisure, and wellness, to view movies, or to receive job assignment. When she first arrived in the MDC, she was handcuffed while seated in a chair watching television. During the first 3 months of detention, she was only allowed 2 15-minute phone calls per month, further limiting contact with her family, most especially with her husband and stepchildren. This is the same restriction that was applied in the MCC's 10 South. The Super Secure Special Segregated Housing Unit, the SHU, for inmates charged with terrorism offenses. A further chill was placed on her phone use when recordings of her calls were improperly released by the MDC to a third party. To forestall further disruption of the privacy of her family, she curtailed social use of the phone, further limiting contact with the outside. That's her choice. She could get more phone time by buying phone cards and things like that. So she could use it in general population. I mean, really? And that's her choice if she don't want to use the phone. That's her problem. Miss Maxwell was denied adequate nutrition. She was provided meager, stale, often rancid, and inedible meals in violation of her non-flesh diet. So she's a vegan, vegetarian, right? And in packing that melted when heated in a microwave. So her non-flesh diet and in packaging that melted when heated in a microwave. What? What kind of stuff was she? At times, she was not provided food for prolonged periods or was given meals missing components. Oh, so she had the burger without the buns. She had burgers without cheese. French fries without the salt. A milkshake without the milk. I don't know. She was denied access to basic hygiene items, soap, toothbrush, toothpaste, and provided only a limited amount of toilet paper. Okay, but hello, she could buy all that shit in commissary. Come on. Oh, brother. They complain about the littlest shit. You could buy all that stuff if you don't have enough. Because they're supposed to provide you with the things, but if you don't have enough, you buy more. For more than a year, she brushed her teeth with an inch-long finger implement until given a normal toothbrush that was never replaced. Her commissary list was restricted, and she was not permitted to order items available to other inmates. Huh? That's messed up. When the tap water in her isolation cell was foul-smelling and undrinkable, requests for bottled water were initially rejected by the prison administration as a result of being provided an inadequate diet. Miss Maxwell has lost about 20 pounds and suffered from telogen effluvium, which is hair loss due to stress and poor nutrition. Now, in the footnotes, it says that even in general population, her commissary is more restricted than other inmates. A unit officer confirmed that commissary operates on favoritism and discrimination. Oh, snap. Well, sorry for you, lady. You must have been a bad girl. Oh. These people are crazy. They're in jail. Like, what the hell are you expecting? The Four Seasons? Oh my God. This is so funny. Complaints made during trial regarding her inadequate daily nutrition were received as a nuisance rather than cause for concern and attention. Right, like you're in jail. You're not going to get special treatment. It's not like you living at home. Yes, I do agree that they should get commissary equally and everyone should be provided these services. But you're in jail, man. You're in corporal punishment mode. You get what you deserve or not. So that's what it is. An extra blanket provided because of the cold temperature in her cell was removed on the claim it had not been approved by the warden, only to be returned when guards observed Miss Maxwell shaking while asleep and became concerned that she might be having seizures. She was given limited time to exercise in an area without sunlight or fresh air, then constructively denied the ability to exercise because she was not provided proper fitting footwear. The treatment imposed on Ms. Maxwell is unnecessarily and intentionally degrading and threatening. While in isolation, a high-ranking prison guard told Ms. Maxwell that there was concern that she would be shot by sniper. Putting aside the reason and propriety of dispensing this alarming information, the dimension of security concerns resulting in her transfer to general population appears correlated to Ms. Maxwell having been sufficiently safeguarded to fill Epstein's empty seat, satisfying the concerns of the government, DOJ, BOP, MDC, prosecutors, court, and accusers. Deprived of sleep and adequate nutrition and subjected to such undignified and dehumanizing conditions of detention, Miss Maxwell was considerably weakened psychologically and had great difficulty concentrating, thwarting her ability to participate in prepare her defense. The impact of the pandemic coupled with the restrictive conditions of her confinement made preparation for trial involving multi-million pages of documents especially difficult. Despite being given a laptop, she encountered persistent technical issues reviewing electronic discovery, at times unreadable on both the laptop and prison PC, and could not search, highlight, annotate, save, or print. Further, delivery of her mail, legal and non-legal, was significantly delayed, as were receipt of Core Link's emails, which were prematurely deleted by the MDC. Now, professional assessment of impact and conditions of confinement. All right, let's see how many more pages we got here. All right, so we got about like maybe 10 more pages of this. Give me 1 second. I gotta take a quick break, guys, for a second. Hold on. Okay, I'm back. Sorry, guys. I had to use the ladies' room, Okay. So now, in this portion, they're going to talk about a professional assessment. Okay. And they're going to talk about, it says, professional assessment of impact of conditions of confinement. So, a report by an independent forensic psychiatrist who evaluated Miss Maxwell throughout the period of her solitary confinement details the debilitating effect of those extraordinary conditions. So it says, see Exhibit J, which is the report by Alexander Sasha Barty. Is that Barty? I think that's one of the doctors that did a report on R. Kelly too. Barty, that name looks familiar. I think so. I'm not sure, but I think I recognize that name. Okay. Now, Dr. Dr. Barty performed an ongoing forensic psychiatric evaluation of Miss Maxwell, including 14 sessions with her from October 20th to August of 2021, including a battery of psychological tests to assess whether any psychological matters were present that might be relevant to the disposition of her criminal matters. Then it says that in summary, Dr. Barty determined, and then as you can see, they blacked out, they redacted the information. We can't see what he said exactly, right? And it continues to say that Miss Maxwell's ability to cope with the stress of her legal proceedings and to participate meaningful in her defense are gradually being eroded over time due to the conditions of her confinement. As reported, Miss Maxwell, observed by this examiner and corroborated by Miss Safian, and in the results of her psychological testing, recently she has manifest symptoms of depression and trauma, such as anxiety and minor cognitive defects. Now, these continue to be exacerbated by ongoing sleep deprivation and the conditions of her confinement. So right here, what I'm reading is more or less a summary of what the doctor said. So her lawyer is kind of giving you a summary of what the doctor was saying. So, given my extensive experience working with incarcerated individuals, based on the manner in which Ms. Maxwell's symptoms have manifest, it is clearly that her symptoms are in no way related to the charges that have been brought against her. Instead, they are directly related to the conditions of her confinement. So the conditions of her confinement are, in my opinion, directly influencing her increasing depression and trauma response symptoms, which will continue to worsen over time if she remains incarcerated under the current conditions. We all have human rights. And yeah, I don't agree with the way they treat everyone because, like I said, even though you're in jail, you still deserve basic human rights. You know, if you're cold, you should get an extra blanket. You know, things like that. You're without a toothbrush, you should get a toothbrush. We don't want you walking around here with stink breath all day. Talking to people. Like, that's disgusting. That's not humane, you know what I mean? So yes, I agree that prisoners should still be treated as humans. But you're being punished. So you got to expect a little bit of punishment. Now they're going to talk about Exhibit J. Okay. In the pre-sentence detention, they're saying that the pre-sentence detention was discriminatory. Okay. Sorry, guys, I'm eating in the background. I'm hungry, y'all. So, pre-sentence detention was discriminatory. In this case, the conditions of detention for Ms. Maxwell were evidently discriminatory. Considering her profile, her age, lack of violence or threat of danger to herself and others, the brutality of her detention regime was completely unwarranted. The fact that she was subjected to an anti-suicide surveillance regime, even though she has no suicidal tendencies, demonstrate that she was being treated differently, without any objective justification. Following the verdict, and in the presence of two officers, an MDC psychologist told Ms. Maxwell she was being placed on suicide watch. The psychologist stated she had opposed placing Ms. Maxwell on suicide watch because Ms. Maxwell did not then and never had presented any suicidal indications. However, the psychologist's professional opinion was overruled per directives from Washington, D.C. Isolated from all inmates and denied social visits due to COVID restrictions. Her only human contact was with the staff that controlled her, except when COVID restrictions for counsel visits were lifted. As such, prison personnel were her primary source of MDC BOP related information, and she often received misinformation. For example, the date by which she must file an administrative remedy. Although legally presumed innocent, she was humiliated and treated in a way that even established guilt cannot justify. The high-profile nature of the case and the defendant has not diminished because the trial is over. Yet, almost 4 months after the verdict, she was transferred to general population because, according to the MDC legal, MDC Brooklyn is entitled to assesses Maxwell's security needs and change them as the facts dictate. Here, Maxwell had been found guilty and will be sentenced sometime this year. As such, the institution does not have the same security concerns it had when she was a pretrial inmate. The institution is aware Maxwell will be housed with other inmates and has instituted procedures to ensure she, like other high-profile inmates, remains safe. Now, it says email from Sophia Papatru, supervisory staff attorney. April 19, 2022, emphasis was added. Now we're going to talk about the pre-sentence detention was equivalent to supermax confinement. Now, I'm eating McDonald's. Oh no, I'm sorry, I'm eating Wendy's. Okay. So the contrast between the typical conditions of Miss Maxwell's detention and conventional confinement is so pronounced that it is disingenuous to describe both forms of confinement under the same terminology, pretrial detention. Ms. Maxwell's detention equated to supermax confinement and punishment. The term supermax confinement, whether pretrial or post-conviction, commonly refers to long-term placement in a SHU and generally includes the following conditions. Cells approximately 8 by 10 feet. Confinement to cells for between 22 and a half and 24 hours per day. Constant monitoring of inmates. No congregation between inmates. Very limited access to activities or programs. And very limited access to visitors, including occurring through thick glass barriers or via video. Although Miss Maxwell's isolation was divided between a small isolation cell and a larger isolated area, she was subjected to all other conditions associated with supermax confinement. Conditions far more arduous than those experienced by I'm getting tired of reading. Those experienced by pre-trial detainees or even sentenced prisoners in general population. Beyond duration of confinement, the quantitative measure of imprisonment. She was subjected to disparate treatment. She was subjected to bad treatment. Example, long-term isolation and unusual restrictions and deprivation, amounting to a profound qualitative difference. Okay. Pre-sentence detention. Uh-oh, what happened? Hold on a second, guys. I'm dropping the link for Noonie. I dropped the link, Noonie. All right, I'm going to wait for Noonie to come up, okay, guys? And she can help me out here. It's a lot of pages. We're on page 29. And this is 77 pages long. But in reality, this memo is only like 35 pages, I think it is. All right. Let me see if Noonie got back here yet. No, she's not in here yet. Okay. So, what do you guys think so far? Let's see. Let me go. Okay, there we go. Let's see what you guys are saying. I'm gonna go up as far as I can here. Noni Boo!
Hey.
What's up, my man?
Hey, what's up?
Say hello to everyone.
Hello, everyone.
So, my Nuni, you're gonna be able to read for me while I'm eating? That would be awesome.
I've been texting you and I was like, I've been asking you since you started. I was like, do you need help? Because I seen it was 77 pages.
Oh my God, I see your texts now. I'm looking at them right now. Well, I do need help now, Mama. Yes, I do. I'm glad you're here, and I know that it's 4:00, so I know you good.
Yeah.
All right, so Mama, you can see the screen?
Yeah.
Okay. So you could start reading the pre-sentence detention.
Okay, pre-sentence detention should not be pre-sentence punishment. Conviction offenders are sent to prison as punishment, not for sent to prison as punishment, not for punishment. Despite complaints made by Miss Maxwell and her counsel, the MDC and BOP officials retained unchecked authority to incarcerate her as they pleased on conditions that constituted unusual punishment for a nonviolent pretrial detainee who posed no threat to herself or others. Ms. Maxwell bore the brunt of unusual conditions imposed by unfettered prison bureaucrats. The Supreme Court defines unusual as something different from which is generally done under an original understanding of the cruel and unusual punishment clause. A punishment is cruel and unusual if it is overly harsh in light of long-standing practice. Ms. Maxwell's conditions of confinement were significantly and unjustifiably harsher than conditions in general population, making it cruel and unusual under the 8th Amendment. Following Ms. Maxwell's arrest, then Attorney General William Barr was intent of making sure what happened to Epstein while in BOP custody would not repeat and issued directives to be applied exclusively to Ms. Maxwell. The rough, discriminatory, and punitive treatment was implemented and condoned by supervisors and wardens, high-ranking MDC personnel, psychologists, and guards commended that they had never seen a nonviolent, non-suicidal detainee subject to such drastic conditions. The treatment was not based on any claim or evidence that Ms. Maxwell was suicidal, dangerous, violent, or in need of discipline. Quite the contrary. The policies and actions implemented to detain Ms. Maxwell violated clearly established rights of inmates to be free from punishment and unreasonable searches. Courts have been confronted with cases challenging conditions of confinement in the MDC, which involved many of the same challenges to conditions of confinement. There can be no dispute that Ms. Maxwell's detention was far more arduous and constituted more serious penalty than conventional detention in general population. While the hardship of imprisonment is normal, measured in quantitative terms by the length of the prison term, the hardship and deprivations experienced by Ms. Maxwell also had qualitative aspects. The difference between Ms. Maxwell's isolation and typical prison conditions is so pronounced that they differ not only in degree but in nature. The distinction demands a different calibration, whereby each day spent in isolation, especially where isolation is not based on any behavior manifested by the inmate, and while the inmate is presumed innocent, should result in an enhanced time served credit. Incarceration during the pandemic supports a well-organized sentence reduction. Courts in this district and elsewhere have acknowledged COVID hardship as base basis for downward variances from the guidelines. But even before the current pandemic, courts have recognized that periods of pre-sentence custody spent in unusual hard conditions merited recognition by courts in measuring the just sentence.
Noonie.
Yeah.
Let me cut in for a second. I'm just gonna say one thing. All right, guys. Let me see. Where was number 21? Where was number 21? Let me look for 21. Hold on. Okay. Shoot. That's my husband. Give me a second, y'all.
Hey, rocking with the truth, Shody, SK, Shaw Baby. Hey, Candy. Hey, Ruby. Hey, everyone. Let's see. Little Valencia is 1 month old today. We're going to have a little photo shoot. Hey, T-Bam.
Sorry, guys, and congratulations, mommy. She's already a month old. Oh my God!
Can you believe it?
Oh
yes.
my God! I cannot. It went so fast.
Yes, it did.
What?
Too fast.
Ave Maria, God bless her. Oh my God, girl, she's gonna blink, 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 and she's gonna be 5.
I know.
So congratulations, happy 1 month birthday, mommy Valencia.
Thank you.
Okay, so what I wanted to say here was, guys, you see how in the footnote it talks about the number 21, right? So they're talking about what they're going to talk about here is about the guards, that they had never seen a non-violent or non-suicidal detainee subjected to such drastic conditions. Now, in the footnote here, Noonie, after you had finished reading that paragraph. Now comes the footnote number 21. Can you please read that footnote and then continue on?
Yeah. Other similarly charged defendants, e.g. Keith Rainier, 18 CR 204 NGG Nexum case, and Robert Sylvester Kelly, aka R. Kelly, 19 CR 286 AMD, were detained in general population. Okay.
So they're trying to use them as high-profile cases who were in the SHU or in general population who were mistreated. So go ahead, Mama. Continue.
Do you want me to say all that stuff or just start at 13 months?
Yeah, start at where it says 13 months. Yes, ma'am.
Okay. 13 months of
case laws.
Okay, 13 months of incarceration during a once-in-a-century pandemic as part of defendant's history and characteristics. In granting motion for compassionate release, the extraordinarily harsh conditions Ms. Maxwell has faced during COVID warrant a downward variance. This court has repeatedly found that the COVID-19 pandemic presents an extraordinarily and unprecedented threat to incarcerated individuals. Let's see. The existence of COVID-19 has created harsher conditions, and that's a fact that the court should take into account. It is beyond dispute that the pandemic has made incarcerated harsher and more punitive than would otherwise have been in this case. This is because the federal prisons, as primal candidates for the spread of the virus, have had to impose onerous lockdowns and restrictions that have had made the incarceration of prisoners far harsher than normal. Let's see. Upon all prisoners during the pandemic may enhance the deterrent effect of prison sentences served during the pandemic by making the conditions of confinement harsher, both physically and psychologically, than they would have otherwise normally be. A day spent in prison under extreme lockdown and in well-founded fear of contracting a once-in-a-century deadly virus extracts the price of a prisoner beyond the imposed by an ordinarily day in prison. While such conditions are not intended as punishment, incarceration in such circumstances is unavoidably experienced as more punishing. Acknowledging that COVID hardship is a basis for the downward variance, courts in this district have given credit for each of pretrial detention served during the pandemic. Oh, shit.
All right, she must have got a phone call or something. Okay, so time served during the pandemic is basically like solitary confinement, harsher than the usual period, more punitive, essentially the equivalent of either time and a half or 2 times what would ordinarily be served. Then it says giving 31 months extra time served, credit for every day spent in deplorably brutal. Excuse me, guys. Go ahead, Noonie.
Okay, my bad. Someone called me. I had to put it on do
I
not.
figured you had a call. I figured that, Mama.
I forget that I have to put on do not disturb or it'll knock my audio out. Okay. So
time served, Mama.
Where? Okay, wait, hold on. Where? Okay. Time served during the pandemic is basically like solitary confinement, harsher than a usual period, more punitive. Essentially the equivalent of either time and a half or 2 times what would ordinarily be served. Emphasis added. Giving 31 months extra time served, credit for every day spent in deplorable, brutal conditions during COVID. 31 months, okay. Having served the entirety of her detention during the pandemic, Ms. Maxwell deserves no less consideration, and because her extraordinarily conditions of pretrial detention were tantamount to pre-sentence punishment, she is entitled to additional significant downward variance from the applicable guidelines. Extraordinarily conditions of solitary confinement justifies a hardship time credit. To determine the nature and extent of which Ms. Maxwell has been penalized, it is important to factor the impact of the hardship of Ms. Maxwell compared to the general population inmates based on the underpinning of punishment and the principle of proportionality. Ms. Maxwell should be given hard time credit for the time she served in restricted and isolated detention. Ms. Maxwell was subjected to punitive conditions and abuse in violation of clearly established law protecting such individuals from punishment, to be free from needlessly harsh conditions of confinement. She posed no danger to the security of the institution, the staff, or other inmates, and engaged in no misconduct requiring her placement in segregation. Confining her to unusually restrictive isolation from the better part of 2 years permits an inference of punitive intent in the absence of any penological reason. The claim that she was segregated due to the high-profile nature of her case is belied by the fact that the case and the inmate are still high-profile, yet Ms. Maxwell is now in general population. If a restriction or condition is not reasonable, related to a legitimate goal, if it is arbitrary and purposeless, a court may infer that the purpose of the governmental action is punishment and may not constitutionally be inflicted upon detainees. Failing to implement reasonable alternatives suggests that a decision to keep her restricted was made by legitimate penological purpose and amounts to impermissible punishment. Let's see. Proportionality supports a hard time credit. The principle of proportionality, a core principle of the Eighth Amendment, and the U.S. sentencing guidelines require the sentences should be relative to the crimes committed. The Guidelines Manual states that one of the objectives at the core of Sentencing Reform Act is proportionality in sentencing through a system that imposes appropriately different sentences for criminal conduct of differing severity. If inmates in isolation or supermax detention suffer 22. Accepting inmates charged with terrorism, discipline for severe institutional infractions and violence, and Mexican drug lord El Chapo. Ms. Maxwell has been subjected to the most unusual and punitive form of pretrial detention. Accordingly, it is appropriate to make sentencing submission that exposes the unfairness of her detention in the hope that the government not repeat such disparate treatment, and the courts recognize that it cannot abandon its supervisory powers to permit BOP bureaucrats to exercise administrative measures without accountability. And continuing, more than prisoners in mainstream conditions, it follows that proportionality requires the severity of confinement be factored into sentencing. Courts sentence convicted offenders to prison as punishment. Courts order pretrial defendants detained to safeguard the community and to ensure the presence of the court proceedings, not for punishment. In evaluating the nature and extent of punishment, it is important to factor in actual impact of the hardship on the defendant. If detention imposes an additional burden on a certain category of defendants, it is necessary to incorporate the actual total burden of the punishment into sentencing collaborations. The principle of proportionality requires that the additional burden experienced by Ms. Maxwell during the 22 months spent in supermax type conditions should be factored into the court's sentencing calculus. Based on the underpinning of punishment and the principle of proportionality, a hard time credit for Ms. Maxwell unusual detention is warranted. Imprisonment in any form is a severe hardship. This is especially so when a person is presumed to be innocent, is detained pre-trial. The standard measure for evaluating the hardship of incarceration is the length of prison term, i.e., a value is placed on the quantitative measure when assessing damages for wrongful conviction, regardless of whether there was a subject mathematical formula. For Ms. Maxwell's unique situation, a meaningful credit is warranted. There is a manifestly stark qualitative difference in the degree of deprivation, restriction, and punishment between the first 22 months of Miss Maxwell's detention and her current detention in general population. Her detention is isolation, de facto, solitary confinement, comparable to supermax detention, involved imprisonment within imprisonment. It was so different from conventional conditions of pretrial detention as to constitute a different form of hardship and tantamount to a different form of punishment. Typically, a defendant receives time served credit for each day incarcerated prior to sentencing. Pretrial detainees have received and continue to receive credit beyond time served for detention during COVID-19. Ms. Maxwell should receive a hardship credit in addition to COVID credit due to restrictive and harsh conditions of her pretrial detention. Conclusion: Ghislaine Maxwell is not an heiress, villain, or vapid socialite. She has worked hard for her entire life. She has energy, drive, commitment, a strong work ethic, and desire to do good in the world. She has supported friends and family through tough times and personal crisis, and currently is assisting women in her unit at the MDC. She has endeavored to contribute to society, e.g. by becoming an EMT, developing a platform so that people in remote areas could receive quality medical assistance, helping launch the Clinton Global Initiative, creating Terra Mar, providing GED tutoring for inmates in her unit, and will continue to do so throughout her sentence when she rejoins the community beyond the prison walls. She also has tried to protect the people around her, Ted Waite's children, her stepchildren, the people at Terra Mar, from the onslaught of press and public vilification that come with having been associated with her. She had a difficult, traumatic childhood with an overbearing, narcissistic, and demanding father. It made her vulnerable to Epstein, whom she met right after her father's death. It is the biggest mistake she made in her life, and one she has not and never will repeat. She has never been accused of anything untoward in the over 15-year period since her relationship with Epstein ended. In fact, she had been involved in 2 committed long-term loving relationships with men who had young children. She is not a danger to the community, and there is no concern about recidivism. In imposing an appropriate sentence, we urge the court to credit a number of factors. Ms. Maxwell being sentenced for nonviolent offense, which occurred decades ago, 1994 to 2004. Ms. Maxwell is over 60 years old. Ms. Maxwell is not a danger to the community in any way. Ms. Maxwell has no prior criminal history or prior bad acts. Ms. Maxwell has served the entirety of her pre-sentence detention during the COVID-19 pandemic. Ms. Maxwell served 22 months of pre-sentence detention under extraordinarily abnormal and restrictive conditions and solitary confinement as nonviolent defendant who posed no danger to herself or others. Ms. Maxwell is being sentenced solely for reasons of punishment. Ms. Maxwell is not being sentenced for rehabilitation. Ms. Maxwell poses no risk of recidivism. I don't know.
She won't do it again. She won't do it again. Recidivism. Go ahead, Mama. Continue.
Okay. In addition, Ms. Maxwell's personal characteristics and history of lawful behavior pre and post dating the offense conduct further distinguishes her situation and warrants sentencing consideration. Probation recognizes that a downward variance is warranted in this case. However, noticeably absent from probation's justification is any mention of detention served during the pandemic and under harsh conditions of solitary confinement. A poll of the CJA panel and federal defenders of Southern and Eastern Districts of New York have resulted in no cases where probation has referenced conditions of confinement or COVID despite requests by defense counsel. This absence is in stark contrast to recognition by courts in both districts and elsewhere in granting downward variances and compassionate release based on the devastating impact the pandemic and unduly harsh conditions of solitary confinement. Probation may ignore these factors, but the court should not. We submit that the appropriate sentence in this case is one that is well below the advisory guideline range. Respectfully submitted, Bobby Steinbein, I don't know.
Sternheim.
Okay.
Right. Thank you so much, Noonie. So that is basically the whole gist of the memo sentencing. Now, there is more. Now I'm going to start. Exhibit A. Okay, remember there was exhibits. There are exhibits of letters in here. Okay, that were submitted. Character letters and the letters by the doctors. Now, this is what I was kind of explaining to you guys earlier that I wanted to show you guys because this is kind of like an example of more or less what R. Kelly's pre-sentencing report should look like. Okay? So in Exhibit A, okay. Just wanted to make sure I had it right here. Okay. Exhibit A is a letter, and it says, Dear Judge Nathan, this is a joint letter from Ann Hulve, nee Maxwell, and from Dr. Philip Maxwell. They are the eldest siblings of Ghislaine Maxwell. We are worried that the legal process, as it moves to its close, might not include information that provides a better understanding of Ghislaine. The traumatic background of Ghislaine began with the 1961 automobile accident to her eldest brother, Michael, who suffered fatal injuries that hospitalized him in a coma for 7 years. Until his death, these were the first 7 years of Ghislaine's life. Accident happened when she was only 3 years old. Our entire family was shaken up by this. My mother gave almost daily attention at Michael's hospital bedside until his death. We believe that forensic psychologists use objective scales of trauma. Also, clinical psychoanalysis could assess her case. Ghislaine's evaluation in this area of trauma could only be favorable to her case. We should say that we ourselves have undergone lengthy psychoanalytical treatment. Oh, I hear you. Okay, wait, which one? All right, hold on. All right, Noonie, got you. You there?
Yeah.
Okay, let me kick this one out. Okay. Sorry, Mama. All right, let me go back. Now, we felt that the quality of the attachment of Ghislaine with Epstein revealed characteristics similar to those of entrapment, affecting those in abusive relationships in this respect. We felt sad that the contribution of the expert in intimate partner violence, Dr. Park Dietz, could not be heard. Her relationship with Epstein began at a moment of extreme vulnerability in Ghislaine's life after the tragic death of her father. He, our father, was a powerful and dominant figure. As the elder siblings, we witnessed our father taking Ghislaine under his wing, whereby she became overdependent on his approval and vulnerable to his frequent, rapid mood swings, huge rages, and rejections. This led to her becoming very vulnerable to abuse and powerful men who had been able to take advantage of her initiate good nature. It is striking that Ghislaine did not show any perverse behavior before she met Epstein. nor did she show any leaving him, which she eventually managed to do. The effect of our father's psychological abuse treatment of her foreshadowed Epstein's own ability to exploit, manipulate, and control her. Given this record, and in consideration that she is not any threat to society, we would humbly ask your consideration issuing a lenient or at least a survivable sentence. We thank you for the opportunity to express our views on our sister's situation. Okay, and this is from the brother and the sister. Then we have Exhibit B. Jamie Martin Holloman. He's a counselor that works in Santa Cruz. Okay. And he states, Dear Judge Nathan, this letter provides evidence regarding Ghislaine Maxwell's character and future that bears on your upcoming sentence in her case. My name is Jamie Holloman. I am a JD graduate of the University of Pennsylvania Law and an MS graduate of the University of California, Santa Cruz in counseling psychology. For the past 27 years, I have practiced psychotherapy, first for Bruce County's Division of Youth and Adult Services from 1995 to 2011. And then, since then, I've run my own private practice here in Santa Cruz, California. I have never treated Ghislaine Maxwell professionally. Rather, I am writing this as a long-time close friend of the whole Maxwell family, including Ghislaine. My father, Dr. Herbert Holloman, met Robert Maxwell, Ghislaine's father, in the mid-1950s because my father was a major research science manager and General Electric Co., and Maxwell was by then already a major publisher of world science. Apart from earlier whole family stays with the Maxwells in the early 60s, my parents sent me back to Oxford for an entire summer for work experience and to stay with the Maxwell family in 1966. Ghislaine was 5. I returned again, hi mommy, in 1980 for more experience that summer and returned multiple times in later years to see the siblings and her mother, Betty, after Robert Maxwell himself died in 1991. So you see how our families met. Hi mama. How we've all been friends for over 60 years and how I've maintained a close relationship with the Maxwell clan for most of my life. Though I was spending more of my time with the older siblings who were closest to my age, I also chose deliberately to spend time as well with Ian, Kevin, and Ghislaine. From early on until they were soon going to prep school together during term time. You may know their father was narcissistic, demanding, and highly controlling. He let them know early that he was going to leave his fortune to charity. So all the kids knew they had to make it on their own, despite the wealth and privilege in which they were growing up. As I got to know each of these kids, including Ghislaine, I noticed that early on, every single one worked very hard at their jobs, as Bob wouldn't bear any idleness, and each strove for their father's and mother's respect through their intelligence and their own hard work. So it didn't surprise me that in her prep school classes, as well as her bachelor's work at Oxford, where Ghislaine had followed her elder siblings, she produced exemplary grades and a reputation as a serious student. I also personally noticed that Ghislaine Maxwell was quick-witted, smart, full of initiative and good humor, and sincerely caring towards everyone she knew. So let me share, Your Honor, my core point here. Ghislaine is a very smart and sensitive person. I observed this since I met her at age 5. I've already heard through her sister Isabelle that she has truly regretted ever meeting Jeffrey Epstein. She has been severely punished with nightly awakenings every 15 minutes in her years, already now in jail. She lost her bid for retrial. Like other smart, insightful people, she fully recognizes how much her whole family has dramatically changed. So she does not need many more months, or certainly years, to pay for whatever crimes the verdict says she committed and aim for rehabilitation. You will surely sentence her in a just manner. I assure you that upon her release, under probation and beyond, just as she never committed a single crime before her arrest, nor will she commit any other crimes, and instead dedicate her entire life and work to helping the world. I knew her to be hardworking and committed to her aims throughout her young life. When I knew her personally, and through her siblings, when I heard about her later on, when she was in New York and elsewhere, I wanted you to be assured of the two things specifically, since I have treated former prisoners myself. First, she didn't need much prison time to learn her lesson the hard way. In fact, I'm sure she already has. And second, she will surely respond to probation responsibility. And she will surely respond to probation responsibly and dedicate her whole life to ocean cleanup from plastics and other debris, or indeed other critical social causes. This is because she isn't stupid. And after all this hellish fate, Epstein, the only way she will be able to create some good out of her life will be through the kind of dedicated work. Her siblings will certainly support that. The faster she can be permitted to rehabilitate herself in that way, the faster she will do only good in this world. More time won't accomplish anything, Your Honor. Please believe me and only sentence her to the lower range of the sentencing guidelines. Thank you very much for your intention. Sincerely yours, James. Then we have Exhibit C. Nuni, you want to read Exhibit C, Mama?
Yeah. Let's see. To Honorable Judge Nathan, my name is Christine Molina Maxwell. I am one of Ghislaine's sisters. I am fully aware of the charges to which Ghislaine has been found guilty. Despite this fact, I continue to hold my sister in the highest regard. This letter is being submitted for your consideration as to her sentencing. My background: I will be 72 years old before the end of this year. I have been married to my husband, an endowed professor of physics and art and technology, for 34 years. I have 3 grown children, an emergency medical doctor, an emergency medicine doctor, a research scientist, and a data scientist. Following in my mother's footsteps, I have humanities PhD in the arena of Holocaust studies from the University of Texas at Dallas. Professionally, I have taught grade school, worked for an editor and marketing director for an international scientific and educational publishing company, and served as a president and CEO of an information broker company and 2 online search engine companies. Today, my internet knowledge discovery companies thrive to help people find actionable insights to foster a better, safer, and smarter world. What I particularly know about my sister, Ghislaine, is a human. Each of us is born into this world with no choice into which family. Ghislaine and my other siblings were all fortunate that our parents were able to provide us with a comfortable upbringing. We've always had enough to eat, a nice home to grow up in, and we all went to good public and private schools. Yes, we were privileged, but we were not entitled, and life was not always perfect. Unfortunately, our family always became a grieving family. Our oldest brother, Michael, was gravely injured in a car accident just after Ghislaine was born. He remained in a coma until his death when Ghislaine was 7 years old. In spite of this tragedy, I watched Ghislaine learn to adapt and become a productive and caring human being. Ghislaine is independent and upstanding, two attributes of our parents are pertinent to understanding foundational aspects of Ghislaine's character. First, both of our parents had an incredible work ethic. We were all encouraged from an early age to work, to earn money, and to respect the responsibility that came with that privilege. I have witnessed that work ethic in Ghislaine. She is a far cry from the media's wholesale mischaracterization of her as just a British socialite. Second, our parents raised us to respect and follow the golden rule, to treat each person as we would like to be treated ourselves. I've never seen Ghislaine show any hurtful intentions or tendencies against anyone, including any living thing. As you have stated on 3 occasions, Ghislaine is not a threat to the public. Ghislaine is educated and hardworking. She found her passion in life at age 50 when she poured her heart and soul into setting up and running a nonprofit environmental organization, the Terra Mar Project. During its development, Ghislaine reached out to me for educational and publishing advice. One measure of its success is evidenced in the major collaborations with entities and organizations such as National Geographic and Oxford University that she managed to secure. These recognized leaders could not afford to be linked to anything but the most reputable entities, which is how they viewed Ghislaine's endeavor. Each allowed their logos and names to be associated on the public Terra Mar website. Ghislaine is a caring person. The goals that she has set for Terra Mar were laudable and reflect her concern for the well-being of the humanity. The only reason why she was compelled to close down the project was to protect the supporting individuals and groups from being hounded and starting to be vilified by the press after her arrest. I know that Ghislaine still very much wants to find more ways to give back to the society. We live in a world where malicious envy of people seem to have wealth and perceived undeserved social position in life is perfect fodder for selling newspapers and filing social media platforms with gaudy single faucet views. Ghislaine had money because she worked very hard to earn it. Her positions demanded hard, diligent work, great intelligence, great management skills, great ability to get on well with people from all walks of life, artistic creativity, and caring for others. Her work was a far cry from the flippity-gibbet socialite, a label that the media has decided to cast on her every time they referenced her. I'm asking you to consider a lesser sentence for my sister Ghislaine. If Ghislaine is able to regain freedom while she still has all her faculties, I know she has much to still offer in dedicating the rest of what is left of her life to advocacy, to helping others. Thank you for your consideration of all the points in my letter that speak to the worthiness of Ghislaine's contributions and ability to her truly wanting to make positive difference again if given the opportunity to do so. Respectfully, Christine Molina Maxwell.
Okay, I'm going to read the next one. Okay, Exhibit D. Letter in support of Ghislaine Maxwell as sentencing. Dear Judge Nathan, my name is Isabelle Maxwell, and I am one of Ghislaine Maxwell's older twin sisters. I am 71 years of age and have known Ghislaine all her life. I am a graduate of Oxford University, co-founder of one of the Silicon Valley's earliest search engines, and a technology pioneer of the World Economic Forum. I am, of course, aware of the charges of which she has been found guilty at jury trial. I have been present at every one of the pretrial and trial court's days. Notwithstanding the jury's verdict, I continue to hold Ghislaine in the highest regard, and I believe very strongly that she still has much of value to contribute in the world. I wish to share some things about my sister that speak to her character and to her values that I have personally witnessed throughout her life, including from the early 1990s right up to today. Despite a very tragic start to her life due to a fatal car crash suffered by our oldest brother, which deprived Ghislaine of the immediate attention of our parents in her earliest years, I observed her grow up and become a lovely, witty, resourceful, scrupulous, and trustworthy human being. Our parents taught us key values such as kindness, consideration, generosity, and extremely hard work ethic. For example, from a very early age of us had to learn and demonstrate what our father termed the 3 C's: consideration, concentration, and consciousness, and to always treat others as you would like to be treated yourself. We were quizzed on these principles constantly and had to regularly report examples of how we followed them. Ghislaine was no exception in deeply absorbing, exhibiting, and living these values. For example, I think it is no small fet to train and become a helicopter pilot, an emergency medical technician, submersible pilot, and more, as they all require dedication, concentration, and quick thinking and reactions, and no small amount of courage. These are not the usual pursuits of a flibbity gibbet or a socialite, terms with which my sister has been branded with to this day. Ghislaine was always an extremely generous, thoughtful, and kind host in New York to her many siblings, including me, and her many nieces and nephews, which I deeply appreciated. She also helped our mother greatly in her late life and exhibited deep caring and concern, which I noticed personally on many occasions. For example, she dropped everything and flew to France at her own expense to help me with medical issues our mother was having and to just be there to comfort her. She also did not hesitate to help her many personal friends with their problems, not only with kindness, but practical help too, and did not ask for anything in return. My sister was also very entrepreneurial in creating and investing in multiple companies and organizations which created products and services, as well as employment. An important example is that in 2012, Ghislaine turned the lifelong passion for the oceans into a nonprofit, the Terramar Project, with the mission to create a global ocean community based on the idea of shared ownership and responsibility of the global commons, the high seas or international waters. Efforts like these to help our planet are sorely needed, and frankly, our fragile Earth continues to need all the help and activism it can get. It would be within our power to allow her to renew her fight as soon as possible for ocean conservation in light of the dear warning just issued by the UN that the Earth's ocean have reached the hottest and most acidic levels on record. Ghislaine has managed to live through the most arduous pretrial detention for over 500 days under an enhanced security scheduled at MDC Brooklyn with courage, humility, and stoicism. During her pretrial detention, she suffered conditions that have consistently and daily contravened the UN Mandela rules of detention to which the U.S. is a party. Examples highlighted by Ghislaine counsel include severe sleep deprivation, a lack of potable water, prison computers that do not function, and inability to access the prosecution's discovery or keep jail guards from reviewing her confidential materials. I am in awe of the depth of her life force and forbearance. This shows me that she will be able to emerge from incarceration with fortitude and magnanimity. I conclude this letter with the reiteration of the government's and the court's own repeated assertions that Ghislaine is no threat to society, and in restating my strongest belief that Ghislaine would bring all her deep and demonstrated qualities to bear again to help society. I hope greatly that she will be given the opportunity to do sooner rather than later. Yours respectfully, Isabelle Maxwell. Exhibit E. Dear Judge Nathan, I write this letter in support of my sister Ghislaine, aware of the charges she was been found guilty of, noting too that she has no prior criminal convictions in any jurisdiction. I have known Ghislaine for over 60 years and have formed a settled view of her good character based on our growing up together and continuing to remain close to this day. I respect her enormously for her generous, often anonymous donations to charities and her valuable contributions to nonprofit and other organizations, for her many personal achievements, which have included obtaining her helicopter license, becoming a banker, an EMT, and a submersible pilot, as well as for the courage she has shown in the face of 2 years of intolerable conditions of incarceration, for her stoicism and indeed humility under such trying circumstances, which have witnessed so many setbacks for her. For all this and many other reasons besides, I hold her high in my affections and shall certainly continue to do so. My sister is aunt to 13 nieces and nephews, now aged 18 and 37, and I have witnessed at firsthand over the years her generosity to them, be it paying their school fees, mentoring them as they grew up, or providing job opportunities for them. She also has an enduring capacity for friendship, a warm heart, and the ability to convert those feelings into action when required to help those less fortunate than herself. She has discreetly supported some friends financially and others by providing a roof over their heads when they were down on their luck, often for weeks at a time. Ghislaine has also been a truly supportive sister. During my divorce from my then wife, my sister allowed me to stay rent-free at her home in London for 6 months when I had nowhere else to go until I was able to find alternative accommodation. She never asked for anything in return. There are actions of a fundamentally good and decent person with great empathy for others and a capacity for altruism. This is the true Ghislaine, whom I know and love as her brother. My sister was fortunate, as I and my siblings were too, in benefiting from an outstanding formal education which culminated for Ghislaine with a good degree from Oxford University. She put that achievement to good effect, using amongst other skills her gift for foreign languages and networking abilities to start up, invest in, and develop numerous businesses in the UK and in the US, employing people, making difference, making a contribution. Perhaps her single most important contribution is to have converted a lifelong passion for conservation and the oceans into a nonprofit, the Terra Mar Project, to create a robust awareness program and a thriving social network around the oceans at a time when they were perhaps not so high up the conservation agenda as they are today. Terra Mar ran from 2012 to 2019 and at its peak had hundreds of thousands of visitors to its website and many thousands of subscribers to its program. None of this would have happened but for Ghislaine's determination, her hard work, and capacity for organizing and mobilizing, and sheer perseverance, as well as financial generosity in sustaining Terra Mar over the years. Those personal efforts of hers, along with others from key corporate supporters and sponsors, were acknowledged when the UN made oceans conservation one of their 17 substantial development goals for 2015 to 2030. I believe Ghislaine still has much to contribute to the world if she is given a meaningful opportunity to do so. Sincerely yours, Ian Maxwell. Okay. Nuna, you still with me, baby?
Yes.
Okay, you want to do Exhibit F?
Yeah.
Okay.
Check your messages too, the private one. Dear Judge Nathan, I write this letter in support of my sister Ghislaine, in the knowledge of the guilty verdicts reached at trial. Ghislaine is my youngest sister by 3 years. I have known her all my life. We have always been close and remain so today.
Got you.
The person described in court by the prosecution and some of the witnesses is completely alien to me. To my knowledge of her, I'm gonna scroll. Okay. Ghislaine is intelligent, warm-hearted, generous, kind, funny, thoughtful, and loving person. She cares about others. Ghislaine's first reaction on the hearing of a problem is how to solve it and how to contribute to a solution. Her desire is always to engage, to bring energy to every problem, and to help. Her care and thoughtfulness has been exhibited to me repeatedly over the years in many individual acts of kindness. To my own knowledge, to friends, family, and many third parties, including employees, whether it was financial help with school fees or providing need accommodation or cash to help out with an emergency or time off for something personal or simply being empathetic, providing time to talk, to listen to someone's problems. Ghislaine's commitment to ocean conservation and the creation of charity that engage with literally thousands of people across the globe is an example of what her drive and determination and ability to organize can achieve. I urge you to take into balance of your consideration about sentencing, notwithstanding the gravity of the offenses of which she has been found guilty. Ghislaine's previous lifetime good character, the high regard and continuing love and esteem from her friends and family based on life's knowledge of her, her character, conduct, and achievements, the very real hope and expectation that she will be allowed to participate with and contribute to once more her family, friends, and society at large. Kevin Maxwell.
Okay, Mama. Thank you so much for helping me to come up here and read. I know you gotta go, baby.
I got like 10 more minutes.
Oh, okay. So then we'll read the next one. Okay, so I'll let you read the next one. Okay. All right, guys. Exhibit G, guys. Oh, I think she got a phone call or something. Okay, I don't know what happened. Oh, there she goes.
Okay.
You got it,
Okay.
Mama.
Dear Judge Nathan, Ghislaine Noel Morion Maxwell, my name is Catherine Vaughn Edwards, and I am sending this letter of support, knowing it is to be represented to the court in connection with the sentencing of Ghislaine Maxwell for the charges that she has been found guilty of in December 2021. The content of this letter is true and within my knowledge. I first met Ghislaine in 1988 when she employed me as her personal assistant at Maxwell's Corporate Gifts, a business she had started herself. I left her employment in 1989, but remained in regular contact and count her as a close personal friend. I helped her move from London to the US and stayed with her in New York for some weeks immediately after the burial of her father in 1991 to help her and provide moral support. I have visited her in the US, stayed with her and her family, and helped when they moved into their new house. I've always met when she travels to the UK. She has stayed with my family, has known my children since they were born, and is godmother to one of my sons. Whilst I fully acknowledge the verdict of the court, I continue to stand by and support Ghislaine, the person that I have known for 34 years, and is not the same as the Ghislaine so negatively portrayed by the press and mainstream media. My own experience is that she is kind, caring, and thoughtful, and is always there to provide support as a loyal and generous friend. She has been a mentor, encouraging and helping me to develop my business, and gives her time and advice freely. Since her arrest, I have written to her and plan to visit her once my application is approved. Respectfully, Catherine Vaughn Edwards. She only worked for her for 1 year.
You see what I'm saying? So if you worked for her, you knew her, you grew up with her, you're a family member, you can write character reference letters. So for those who are out here on these streets screaming, the way they be screaming, you need to do this because they say they know R. Kelly. So if you know R. Kelly, you should be able to present a character reference letter.
Mm-hmm.
But if you don't know R. Kelly, you can't do shit.
Mm-hmm. Exactly.
So that's that, propaganda that people.
And that was a friend. That wasn't a family member. So,
right.
Okay,
It's
Dear Judge Nathan, my name is Harriet Jagger, and I have known Ghislaine for 45 years since we were at school together. We have always kept in touch, and I have been writing to her regularly whilst she has been in prison. I am, of course, aware of the charges of which she has been convicted, but my love, care, support, and lifelong friendship of hers remains unchanged. I believe that true friendship and understanding of what a person's life journey takes, with its many twists and turns, is always a test. I first met Ghislaine running down a corridor at school. She was 15 and carrying 2 pairs of corduroys, one green and one black. She had great energy, a huge smile, and I liked her immediately. She was very popular at school, bright, kind, engaging, and fun. Being close friends, we have, of course, had social times, the help with advice on personal issues, the connection of like-minded people. I totally trust Ghislaine to always be there for me, the same as I am for her. When I was going through a sad separation with my husband and living in a lowly rental, Ghislaine would often ring me with a call me if you need cheering up, knocking on the door to see if I was okay. Do you want me to nip to the supermarket for anything? I have always liked her straightforward, intelligent advice, her strong personality, but with a genuine, sensitive understanding of people's problems. Her warmth, devotion, and huge loyalty to her family and friends are qualities I admire enormously in her. We had trips together, most notably to Madrid when we were both working on different publications. I was showing her the ropes of the industry. She was happy to listen to other people, take on board experiences and knowledge from those in the business. She was open and friendly, often lacking in confidence herself. She would work hard to understand and appreciate those who knew more. Despite being being on different sides of the Atlantic, we have always remained friends. Ghislaine was always quick to answer message, to meet up wherever possible, mean to help, a grounded attachment to those she valued and were constant in her life, wanting news, catch-ups, and gossip of old friends. The last time I saw Ghislaine was in her home in New York a few years ago. I listened to her as she spoke of her wish to find the security and happiness with a family unit. She was visibly upset that the simplest things for so many others, had not been a part of her own life. I felt hugely sorry for her, having known her a large and great family, her love and great respect for her parents and closeness to her brothers and sisters. I knew this was something she had always craved. I gave her a huge hug on departing, so I was then thrilled to learn that she finally met and married someone and was helping to bring up his young children. But then desperate to hear that this much sought after joy was short-lived. I read constantly in papers and social media about her, often from those who have never met her. But this is not Ghislaine I know and have known for 45 years. This is not a true representation of the real person, my loyal, trusted, and great friend. This person is not Ghislaine. I can only plead for the court to show her some form of mercy and understanding with a sentence that is survivable, as I honestly believe she has much more in her life to give. Sincerely yours, Harriet Jagger. Okay, I'll be back if you're still on, okay?
Okay, my love. Be good. Thank you so much. Gracias mucho, mami. Tú sabes.
Okay, bye.
Bye. Thank you so much, Noonie, for helping me out with that, baby. Thank you. You gave me a chance to read and all that good stuff. Eat. Give me a chance to eat behind the scene. Okay. So, let's continue. All right, guys, I'm not paying attention to that. Let me look at my phone here. What we got going on? Y'all talking about McDonald's. Y'all crazy. That sounds better until that part contradicted. I discern exactly what she was doing. If she cared so much, there's a better way to advise. Yeah. Tina Shorty, you could have let Diva know with the timestamp instead of posting the negativity in this live. No, I said you have to leave that Diva also has you could have posted. Okay, what is going on in here? I agree with you. I always am. Okay, what is going on here? I didn't give that any energy. I mentioned somebody said something about me in another chat. What? Wait. I mentioned what someone said in another chat about Diva and her daughter. Okay. All right. All right. I'm gonna continue to look at. I'm not even gonna. Okay. Let's continue because I'm not gonna get distracted by that. I'll just speak about it after. Okay. Exhibit 1. Dear Judge Nathan, my name is Jeffrey Roth. I am on the staff of the New York Times, and I am a cousin of Miss Ghislaine Maxwell. We have known each other for 50 years. My mother, Joanna Roth, and her late father grew up together. Our families have been close for 90 years. I attended the trial as a family member and am aware of the charges that she has been found guilty of. Ghislaine is a friend and confidant, forthright, kind, respectful, qualities that all parents hope for in their children. I saw those in Miss Maxwell many times, and especially towards her late mother, Elizabeth. When Betty would come to the States, I would come by, and here's what I observed. A kind, caring daughter who was respectful to her mother and to all around her. Qualities learned and inherited and apparent to all. That's who Ghislaine is. Respectfully, Jeffrey Roth. Exhibit J. Dear Miss Menninger and Miss Sternheim, I am performing an ongoing forensic psychiatric evaluation of Miss Maxwell to assess whether any psychological matters are present that might be relevant to the disposition of her criminal matters. In this letter, I address her current mental state and risk of flight in light of a pending bail application. I have met with Miss Maxwell on numerous 14 occasions, from October 2020 to the present via telephone interview, via telephone conference, and one in-person meeting at the MDC on April 22nd of 2021. Now, during those meetings, I reviewed her personal, social, educational, vocational, and psychiatric histories. I performed a mental status examination to assess her intelligence, thought processes, cognitive functioning, memory, credibility, orientation, judgment, insight, and impulse control. Now, let me interject for a second. So this is the kind of psychological evaluation that was done on R. Kelly. They had to assess his intelligence, his thought processes, his cognitive functioning, his memory. They had to check his credibility, his orientation, his judgment, his insight, and his impulse control. Interesting. I wonder what that report looks like. Oh boy, I want to know so bad. I'm really a nosy mofo. I want to know. I reviewed, now let's continue. I reviewed numerous legal correspondence between Miss Maxwell legal counsel, MDC Legal, and the Honorable Allison J. Nathan. Additionally, I conducted a collateral interview with Miss Leah Safian, part of Miss Maxwell's legal counsel and a longtime acquaintance. Now, on July 16th of 2021, to gain insight into Miss Maxwell's current level of functioning, the limits of confidentiality inherent to such an evaluation were explained to Mr. Maxwell, it says here. Term of incarceration. Now, this is the forensic psychiatric report on her. Okay. Ms. Maxwell reported that she has filed over 100 grievances regarding the conditions of her pretrial confinement since her incarceration at the MDC in July of 2020. I reviewed numerous grievances filed to the court by Ms. Maxwell's legal team since her incarceration, which allege that Ms. Maxwell has been subject to physical and emotional abuse by the correction officers, poor and unsanitary living conditions, malnutrition, difficulties reviewing the millions of legal discovery documents in the case against her, and sleep deprivation. She is currently housed in segregation from all other inmates, reportedly with a team of 10 correction officers at a time. 3 officers are on duty from 7 a.m. until 8 p.m., and 2 officers from 8 p.m. until 7 a.m., groups of which rotate on a bi-weekly basis, and many of the officers are reportedly often hostile towards her. There are cameras on her constantly. Some are stationary, and one camera is on wheels and follows her as she moves throughout the facility. Miss Maxwell reported that she has been threatened by correction officers that she will be subject to discipline if she is ever out of the camera's view. Miss Maxwell reported that she is subject to numerous pat searches per day, despite being completely isolated, during which she alleges to have been touched in a sexually inappropriate manner by correction officers on multiple occasions. Ms. Maxwell reported that in January of 2021, a correction officer grabbed her breasts with intense pressure during a routine pat search, causing her significant discomfort and pain. She reported that she often refuses to go to recreation to avoid being searched, which has negatively impacted her physical health because she is unable to get fresh air or exercise. She was reportedly denied an extra blanket in the winter, and on more than one occasion, an officer took one of her blankets from her after she requested for an extra blanket was granted. She further reported that she was not provided a proper food regimen for the first few months she was incarcerated, wherein she was provided with small, inadequate portions of rotten food. She had reportedly lost at least 15 pounds since her incarceration and has experienced hair loss. She reported that currently she suffers from constant headaches and back pain. Ms. Maxwell is subject to flashlights being shined on the ceiling of her in 15 minutes intervals every night since she has been incarcerated. A letter authored by U.S. Attorney Audrey Strauss states, MDC staff conduct flashlight checks every 15 minutes because the defendant, while not on suicide watch, is on an enhanced security schedule. Because MDC has identified a number of factors that raise heightened safety and security concerns with respect to this defendant. So Ms. Maxwell reported that these flashlight checks have significantly hindered her ability to sleep, as she frequently wakes up every time the guards shine the flashlight into her cell. When she was brought from the detention facility to court, she was awoken at 3 a.m., transported, and held in a cold cell for hours prior to her scheduled court appearance. Upon my initial meeting with Ms. Maxwell in October 2020, she did not manifest psychiatric symptoms of any kind. She was coherent, optimistic, and confident in her ability to defend herself in court. Over time, she has manifested depressive symptoms, anxiety, and minor cognitive defects. More recently, during our meetings, Ms. Maxwell has been depressed, fatigued, anxious, and tearful. She endorsed experiencing irritability, memory deficits, inattention, word-finding difficulties, and trouble organizing and sequencing her legal documents. Despite her symptoms, Ms. Maxwell has maintained her innocence and continues to express a determination to fight her case. Let me get something to drink. Collateral interview. I conducted a collateral telephone interview with Miss Leah Safian. Miss Maxwell, sorry for the chop up. Miss Maxwell's longtime acquaintance and part of her legal team, to gain further insight into her current level of functioning. Ms. Safian reported that she has worked with Miss Maxwell's family since 1991, and she represented her brother Kevin Maxwell at that time. She was reportedly hired to legally represent Miss Maxwell in 2015 and has spoken to her on the phone every day since that time. Since Miss Maxwell's incarceration, Miss Safian has spent approximately 6 hours per weekly day on video conference with Miss Maxwell, during which they review legal discovery documents to prepare her defense for the upcoming trial. She described Miss Maxwell as highly intelligent, well-educated, exceptional in so many ways. However, she stated, I have seen her deteriorate since her incarceration, which Ms. Safian described as frightening. She described the conditions under which Ms. Maxwell is being detained as psychological torture, in that she is being held in a quasi-solitary confinement, where the officers assigned to her are often hostile. Ms. Safian characterized Ms. Maxwell as vibrant and witty prior to her recent incarceration. However, she reported that currently, due to sleep deprivation and the conditions of her confinement, there are days when Miss Maxwell is so exhausted that she can't string a sentence together. She often misuses words and she struggles to maintain focus. Ms. Safian reported that Ms. Maxwell is the most important asset in her own legal defense, as there are millions of legal discovery documents to review, and Ms. Maxwell has been the primary source of information to string together the facts of the case. Ms. Safian added that Ms. Maxwell is often the one to notice factual errors within the legal discovery that her legal team often does not pick up on. However, due to marked deterioration since her incarceration, it has been increasingly difficult for Ms. Maxwell to sustain her attention to do so. Ms. Safian added that recently Ms. Maxwell has completely lost her sense of humor and often misses the beat. Ms. Safian reported that she does not consider Ms. Maxwell to be a flight risk, as she had the opportunity and means to do so prior to her arrest, but she chose not to. Wow. So, Ms. Safian added that recently Ms. Maxwell has completely lost her sense of humor and often misses the beat. I wonder if R. Kelly lost his touch for singing. Is he depressed in there? If he's depressed, he might lose his senses too. You know, it happens to us. You know, we get unfocused. We don't, depression is heavy. It does a lot to you. You're always tired. A lot of times you don't want to eat. Sometimes you don't even want to get out of bed. Those things happen. So Ms. Safian reported that she does not consider Ms. Maxwell to be a flight risk, as she had the opportunity and the means to do so prior to her arrest. I mean, she did leave to another state, however, she upped and left her husband and her kids, but she said it was because she did that so that the media and others that were trying to threaten her and stalk her and look for her, she just wanted to hide out. It wasn't because she wanted to flee, right? So Ms. Safian stated, "If I was permitted by law to post bail, I would put my house on the line without hesitation." And then she stated some other things that we are not privy to see. Okay. So they redacted the rest of the report. Okay. Then it says that in formulation, Ms. Maxwell is a 59-year-old Caucasian woman who is being evaluated at the request of her attorney in order to assess her current mental state and risk of flight. Ms. Maxwell has described and complained formally of being subject to unfair and inconsistent treatment by correction officers and ongoing sleep deprivation throughout her incarceration. Research indicates that the experience of unfairness, disrespect, and lack of safety significantly contributes to psychological distress in incarcerated individuals. Furthermore, recent research on the effects of sleep deprivation on cognitive functioning states that sleep deprivation resulted in a loss of cognitive flexibility through feedback blunting. Sleep deprivation causes a fundamental problem with dynamic attentional control. Furthermore, one study showed that Ms. Maxwell's ability to cope with the stress of her legal proceedings and to participate meaningfully in her defense are gradually being eroded over time due to the conditions of her confinement, as reported by Ms. Maxwell, observed by this examiner, and corroborated by Ms. Safian, and in the results of her psychological testing. Recently, she has manifested symptoms of depression and trauma, such as anxiety and minor cognitive deficits. Cognitive stuff. These continue to be exacerbated by ongoing sleep deprivation and the conditions of her confinement. Given my extensive experience working with incarcerated individuals, based on the manner in which Ms. Maxwell's symptoms have manifested, it is clear that her symptoms are in no way related to the charges that have been brought against her. Instead, they are directly related to the conditions of her confinement. The conditions of her confinement are, in my opinion, directly influencing her increasing depression and trauma response symptoms, which will continue to worsen over time if she remains incarcerated under the current conditions. If she were permitted to be released into the community, her symptoms would likely resolve completely, and she would be afforded the opportunity to properly prepare her defense for her trial. At this time, Ms. Maxwell currently poses little to no risk to the community, and she has no prior history of criminal or violent behavior. And her current charges could only have been manifest under a very specific set of circumstances which she cannot find herself in if she were to be released. Additionally, in my psychiatric opinion, she is not a flight risk, as she has maintained a strong desire to fight the case against her despite any psychiatric symptoms that have manifested. Ms. Maxwell has the personality characteristics of a fighter. She has demonstrated a firm resolve to fight her current charges and clear her name. There is no indication that she would attempt to flee given her personality profile. Respectfully, Alexander Sasha Bardi, MD of the Fifth Avenue Forensics. Okay. And that is the end of that, guys. So, all I got to say is, Miss Maxwell, you'll get used to it, honey. Don't worry about it. You'll get used to it. It takes some time. It's not what you're used to in your regular lifestyle. But eventually you will get used to it. You just got to break out of your old habits and learn your new ones. And roll with the punches. Hang out with some of those inmates and learn the ropes of how to survive in there, girl. You will be okay. You will be just fine, okay? You will be okay. Just like R. Kelly, just like Keith Raniere. Yous will be okay. Yous are all getting the punishment you deserve and you need. And I hope yous all get the help you need at the same time. Okay? She will be all right. She will be all right. Okay, now. That is the end of that for her. And just because all of those character letters and letters from the psychiatric and psychologists and everybody else does not guarantee that they're going to knock down her 55 years that they want to give her to 20. That doesn't mean anything. Doesn't mean anything. But, you know, the judge could have leniency. You know, she's trying to show some type of reference that she's a good person of good character. And she's educated and she's helped out people in their personal lives. You know, so, yeah. As we know, her sentencing is June 28th of 2022, the day before R. Kelly. So that should be interesting, guys. So this was a truly long read. I'm glad you guys stuck with me for the past 4 hours. We just read like 77 pages. Okay. And wow. Let's see what her sentencing is going to be like. Okay. Let's see. So guys, please do me a favor while you are in here. Do not forget, jump out this chat. Please make sure you hit that like button. Please hit that like button. Keep me in the algorithms. Thank you very much, guys. I appreciate that. You guys already know what time it is. If you're not subscribed to the channel, please subscribe to the channel. Thumbs up my video. Hit the notification bell on all. And if you are watching the replay, please make sure you leave your comments in the comments section in the video. Thank you very much, guys. And Diva Divine Light is out. Peace.